Yes, my lord. Here, my lord, leading counsel M. Kato is out of the station. The matter may be adjourned for the day.
It's an adjournment on the ground of the leading counsel being outstation. List the matter after next week.
Next week.
List the matter after a week. Any interim order? Is there?
Yes, there is interim order, my lord.
The interim order dated so and so shall stand extended till the next date of listing. Next.
Deeply ordered.
Yes, tell me.
Lordship, I beg to mention item number 7.
Okay.
I'm appearing on behalf of the petitioner,
Petitioner.
counsel for the petitioner.
Petitioner.
Who is counsel for the petitioner is outstation advocate,
Yes.
and as such,
Not today, another time.
we have come to a fixed date with the other party,
Okay, that's
and
good.
the date might be 27/11 of this
Okay.
month.
Your good name, please.
A Gamre.
Learned counsel submits that the leading counsel SK Medi is outstation counsel, and with the consent of the other side, prays that the matter may be fixed on 27/11. 2025. Prayers allowed. List the matter on 27/11/2025. Any interim prayers there?
Interim
orders there?
yes.
Interim order, right, that or dated so and so stands extended till the next date of listing. Next.
Obliged.
May I plead your lordship? I beg to mention item number 8 and 9. It is a connected matter, your lordship.
Criminal appeal.
Yes, your
Okay. Why it's come up?
your lordship. I'm appearing on behalf of B typo, your lordship. The clinic.
Appellate
Yes, your honor.
Appellate.
Yes, your lordship.
counsel. So orders.
Here, my lord, the service is not completed, my lord.
Service
In
not-
respect number 2.
I see.
So, await for the service report, my lord.
8 and 9, service upon the private respondent / informant side
Yes.
is not complete. The same may be awaited. List the matter after.
2 weeks, my lord.
Okay. Is he in custody? He's in custody.
No, my lord.
He's not-
Already suspended, my lord.
Oh, okay. It is submitted that sentence has been suspended and the appellant is on bail.
Yes, my lord.
So list the matter after 3 weeks.
3 weeks, yes.
3 weeks. List the matter after 3 weeks. 8 and 9.
Obliged.
Hello, guys.
My lordship, I beg to mention item number 23. Lordship, this matter may be listed of part heart method before the Honorable Justice B. Habung.
Oh, it's okay. Yes. It is not indicated. It's part of matter.
Yes, Lordship.
Learned counsel, good name, please.
B. Sibo.
P. Sibo, learned counsel submits that the matter is actually part heard and may be listed before the appropriate bench, right?
Sorry, my lord.
No.
Matter is not part hard, my lord.
It's not indicated
Not
here.
part hard.
It's not
No,
indicated.
no,
Let's see the file there.
not part hard.
That's why I did not mention the name of the judge because I have not seen the file. Huh? Which one? This one? 22. Sorry, this one. By order. Must have been mentioned. It was heard before Justice
Yes.
Habung.
Justice Sabung has heard it on 2 occasions, but it is not part hard.
I see. Okay.
So this is a simple issue involved, but it could have been done today.
Okay, it is already delved into the matter, and maybe as you wish, whatever.
My lord, let it be after 2 weeks.
Okay, then I should not say part hard, right? The Lord Council submits that you just write this much, no? That the matter may be listed. I say that on 2 weeks, after 2 weeks. Adjourn for the day and listed after 2 weeks. Prayer is allowed. List the matter after 2 weeks. Written argument is also there from your side, I believe.
Yes,
You're for the respondent.
I am the appellant, my lord.
You're the-
It's a second appeal, my lord, but very simple issue involved.
Okay.
The appeal, my lord,
Uh-huh.
the appeal was time barred.
Mhm.
No delay connotation was time, and the decree was not challenged. It's simple issue.
Degree was not there.
Not there.
Okay.
Applied.
2 weeks.
Arguing on facts, my lord, all these days.
Anyway, next
And-
next date you do it,
Yeah.
and suppose you address your arguments, then keep it as part hard.
Yes.
It will not, it will then preserve your effort.
Fellowship, mention for admission hearing on
This
coming Monday.
Monday.
Yes.
Fellowship.
Lordship, I beg to mention item number 21 on behalf of D. Mehdi.
Order matter, 21.
Kindly fix the meters on 18 November, sir.
Learned counsel, good name, please.
M. Boko.
Seeks an adjournment for the day and prays for listing the matter on 18th November. Item 21, madam.
Sir, 24.
24.
Yes, sir.
Oh, I see. Sorry. 24. Matrimonial appeal.
Yes.
List the matter on 1811. 1811.
May I, Your Worship, I beg to mention item number 12. Here I am for the appellant and here as per the service report still awaited incomplete. So I may be allowed to take fresh step.
You for the appellant.
Appellant
Good name, please.
T. Nima.
Nima learned counsel appearing for the appellant submits that seeks to take submits that the appellant shall take fresh steps upon respond number.
Sole respondent, one,
All the respondents.
only sole
All-
respondent,
Sole respondent.
And Your Honor, in this interim order is there.
Entry mod. You take the steps may be taken expeditiously. The interim order dated so and so stands extended till the next date of listing. Since you are taking steps, let it be after 4 weeks. Or what do you suggest? 4 weeks?
4 weeks. Deeply applied.
Item number 1,
May I please, Lordship?
Please.
Lordship, this is an application under section 528 of BNSS 2025 challenging the order dated 28/8/2025 passed by the Learned Specialist NDPS Act, UPR Papumpare in NDPS case number 11/2025 arising out of Naharagun PS case number 119/2024 under section 21.
I remember.
Yes, Lordship.
I remember, yes.
Yes,
This was,
Lordship.
his bail was cancelled, right?
Yes,
his
Lordship.
bail was-
In page number 16.
Yeah, I know, I remember. So, ma'am, you're, Sahagi?
Yes, Lordship.
Yeah.
Yes, Lordship. Bail was cancelled, Lordship, because the condition, Lordship, he was violated, Lordship.
Okay.
Lordship, in the para 2, Lordship, it is reflected that scene and periodic record of the case is found that the court, while granted the default bail, where he was already granted on default bail, Lordship, on 7/12/24 in BN number 424/24, Lordship. One of the conditions imposed upon him was that he shall not commit any similar nature of offense at bail, Lordship. But the Lordship, it is observed that the accused has committed similar nature of offense at Laluk, Assam, and got arrested. This so that he has violated condition of the bail granted to him. Hence, his bail stands cancelled, Lordship. So that Lordship, after that, he has been sent to the
Judicial custody.
Yes, Lordship. So Lordship, that means Lordship, he's a habitual offender, Lordship. He's already, Lordship, so many.
That
cases,
is true,
Lordship.
ma'am,
Yes,
but the thing is that, I actually, this matter, without going into much into the merits of whether the bail should have been cancelled, notice is required to be
Yes, Lordship.
being cancelled. That was not done, I think. In
Yes,
that
Lordship,
case, it
that
might
is there.
require interference to send it back.
Yes, Lordship, that is there, Lordship. Otherwise, Lordship, will call for the case study, Lordship, because Lordship,
I thought the case diary would come today.
no, Lordship, we have not received any case study, Lordship.
Your Lordship.
Unless of the notice was not issued, Lordship.
Or should we dispose it off with the direction? Because in that case, he has to be released.
Yes, Lordship.
Because because he has to be released. Because the bail cancellation order would become untenable.
Lordship.
If we are sure that notice was not issued, then it will have to be remanded.
Yes,
But
not
on the
issued.
existing materials, can we say,
Lordship,
No,
later, Lordship, I just saw that maybe.
take an instruction?
I'll take instruction.
I think it is not reflected, but I think I don't know, it was in my mind. But kindly take the instruction. We should never be afraid of facts. Fact is a fact.
Yes.
Notice was issued or not issued. If
Yes,
it is
yes.
not issued, no issues, we'll remand it back.
So far as my knowledge, there were no issued any notice, Lordship,
Yeah.
to the person.
Most probably it was not issued. That is what it appears, but officially let it come with an instruction.
Yes.
And if it is not issued, then we'll remand it back
Yes.
without going into merits, and you'll be issued notice. And then the court will take a call on whether he has, because he has to be given, because cancellation of bail is a serious matter.
Yes, sir.
So he has to be given an opportunity. No, that is what the law is also. So, Feroz, the last order dated 6/11/2025. Though the petitioner side has contended that there was no notice upon the accused before cancellation of his bail, but the learned prosecution may take instruction regarding the same on or before the next date, so that the matter can be adjudicated. As per law. List the matter on
13 November, Lordship. 13 November.
14 November, Lordship.
don't take it on Friday.
On the
I may
13th,
have
then,
some difficulty on.
Thursday, Lordship.
Take it on 13.
Yes, Lordship.
Obliged, Lordship.
12 or 13. Can you get it on 12?
13, Lordship.
Short 13. 13 left,
Obliged,
right?
highly obliged.
Item number 2.
Yes.
May I please, Your Honor? Oh, Your Lordship. Your Lordship, this is a joint criminal petition, Your Honor, filed under 528 of BNSS, Your Honor, seeking for quashing of proceeding arising out of ITA WPS 30/17 under section 498A/323 of IPC, Your Honor. Your Honor. Herein both husband and wife, both are the petitioners, Your Honor.
Hmm.
The instant case is pending before the Honorable JMFC UPR. The charges was framed on 26/8/2025 and it's currently at a stage of PWS, Your Honor, prosecution witness.
Prosecution.
Yes. The instant petition is filed on the ground of mutual settlement between the parties, Your Honor. As such, they have entered into an agreement on dated 3/11/2025, Your Honor.
Hmm.
Hearing Your Lordship, the petitioner 2, who is the wife of the petitioner number 1, who is husband, had lodged an FIR against the petitioner number 1 on dated 5/4.
Yes, I've seen that.
Yes.
Regarding domestic violence and
Yes.
498A.
Yes,
It was registered, now its charge was framed, now it is at the stage of trial.
yes.
The state is also a party, right?
Yes, ma'am.
You are appearing for the wife
No, I'm for the state, my lord.
or you have the prosecution. So at this stage, what we can do is, we get get some documents.
Yeah, you can copy of TCR,
We
my
get
lord.
a scan copy of the case diary and charge sheet would do.
My lord, the
Deposition.
TCR will suffice, my lord.
TCR will include it.
Yes.
Sometimes many unnecessary things also come in TCR. So, since we'll need the depositions,
Yes, no.
and that agreement has been submitted in the court,
Yes.
that trial court.
No,
It has not been submitted.
No.
Where it has been submitted in the,
Yeah.
before the police,
no. Here is,
in this court.
yes.
It's non-compoundable offense, my lord.
That's true.
Yes.
That is true, but
Yes.
no 320 won't come. But
Yes, 323 won't come, 498A, my lord.
No, sorry, 320 won't come,
Yes,
cannot
yes, yeah,
compound.
absolutely, yes, yes. 482 or
but-
528.
but it can be quashed.
Yes, madam.
That's well said.
Yes, ma'am.
And I think you also issue a notice to the, since she is also a petitioner.
A joint petitioner, my lord.
Actually, ideally, I don't know. Subject to correction, I feel that it's always a better idea because it's not a compounding petition, right?
Yes,
In a
yes,
compounding, you can file a joint petition.
Yes.
In my humble opinion, it is always better that the petitioner accused stands on one side
yes,
and the respondent, though they might have an agreement, no problem. I'm not saying that we'll
they
take
come
it-
with an
we'll take
affidavit,
it up
my
in
lord.
this form.
Yes,
But I think that will be a better model. But the other party, the victim, is made as a respondent, respondent number 2. Issue a notice to the person, she
yes,
comes and says that, yeah, I support the
Yes,
agreement. That's best, actually. Right? Because this is perfect for a compounding. And
Yes.
this is seeking a quashing, right? So anyway, the accused petitioner, Jomo, heard learned counsel, good name please.
DD Rajiv.
Heard learned counsel for the thing. And your good name please, sir. Additional.
my lord, T at token at
Additional public prosecutor.
Yes, madam.
For the state. The accused petitioner here in Jomo Nirmal is stated to be the husband of the petitioner number 2, Yok Anna, who is the informant of the case. and had lodged FIR dated 5/4/2017 alleging cruelty and domestic violence, whereupon Itanagar PS case number 30 of 2017 was registered, investigated, and the same resulted in a charge sheet. Full stop. Subsequently, charges were framed by the learned trial court, and the case is stated to be at the stage of prosecution evidence. Both the informant and the accused petitioner have arrived at a settlement, a copy of which is annexed with the petition. And rather, the informant has joined as petitioner number 2 in this petition. Call for the scan TCR. That will
Yes,
do.
my lord.
Scan TCR. Okay. And also issue notice, whom to issue notice? She's a petitioner.
For me, for state only, my lord, not required for any, no, since there is no any private response.
That will be, I would humbly suggest
Yes,
to
madam.
the learned councils that it is be better.
Yes,
For
it will be
compounding, this is okay.
Yes,
It's
yes.
Now it's done.
If
compounding.
they come with the
Both of us
affidavit-
together seeking compounding. But if it's quashing, it's better to keep her on the respondent side.
Your lordship, next, after 3 weeks.
Oh, this needs to be stayed.
Yes, madam.
In the circumstances, further proceedings of, help me with the GR number.
Yeah, yeah.
GR number 184 of 17.
184 of 2017. Quite old, isn't it? Pending before the learned JMFC UPR District Papumpare AP shall remain stayed till the shall remain stayed till the next date of the
Yes,
stay.
yes. After 3 weeks, madam.
List the matter after 3 weeks.
Yes, sir.
If
Deeply
it does not come up, you make a mention.
obliged.
Item number 3.
Yes.
Lordship, this is a criminal revision petition filed under section 50 of Assam Frontier Regulation Act.
Criminal revision.
Yes, criminal revision, Lordship. Lordship, in this case, petitioner,
For
We-
quashing. So
yes, no. This quashing of the order passed by the Paul Sangram Circle Gaon Bura Welfare Association.
Nice.
It's in page number 68, Lordship.
68.
Lordship, backdrop of the case is that petitioner, who is a counsel, who is appointed by the respondent number 1 and 2
As
as a counsel lawyer.
Okay.
To represent various cases, land related cases.
received an application from so and so complaining against advocate so Chris cheating, manipulation, competition, and frustration.
On 20/12/2022, a joint representation,
Which is the page number?
66, Lordship.
I was on 68.
Lordship, 68 is pursuant to the
Or-
complaint.
This is the order which is
Yes.
passed, no? Calling in for a local mail. That was in
Yes.
March 2023 itself.
Yes, Lordship.
Let us see what is 66.
Lordship,
Yes, 66.
yes. This was addressed
To
to
the
the
president.
president.
Okay,
For conducting a mail order.
this was the complaint.
Yes.
Okay.
Pursuant to
You
this
can read it.
complaint,
Shall we read it?
yes, Lordship. President, General Secretary, Gaon Bura Welfare Association, Sangam.
2012-22, right?
Yes, Lordship, 2012. Request for mail order. Tamche Losik versus Advocate Tai Shiva / Tamo. Respected, sir.
Heard my learned friend saying, the application is filed under section 50 of the Assam Frontier Regulation.
Mhm.
this provision has been deleted in 2021.
Yeah, that's what I thought.
Your Lordship may, your Lordship can obviously convert into 227.
In that case, it will be a civil revision.
Yes, it, or no, or criminal revision, I'm sorry,
Criminal.
criminal, maybe another criminal provision, but 50 has
It's a
been
criminal,
deleted.
it's a criminal matter.
Yeah, I don't know, my lord. I just heard my learned friend
Yeah,
saying.
yeah.
section
Let us,
50.
delve-
Last page, my lord.
Now the CO, Arunachal Pradesh Civil
Yes,
Courts Act.
Yes,
Now this takes over.
yes. My lord will see, say, section 27, last page, my lord.
Mhm. Yes,
Section 27 also.
section,
Then my lord will come to,
section 27,
subsection-
amendment of the.
yes, amendment of the Assam Frontier,
Mhm,
subsection 12, Roman 12,
mhm.
46, 47, 48, 49, 50 shall be deleted.
I see.
50 is deleted,
So now this revisional provision is not there.
not there.
Okay. So what would be the remedy now against this kind of
My lord,
grievance?
if it is a civil matter, it will have to be 227,
That
my
is
lord.
civil matter 227,
Yes.
3 CRP,
Yes,
or criminal matter, PT 482.
yes.
So let us see
Yes, my lord.
what is this matter? Yes, kindly read that.
Lordship, with due respect, humble submission to your office, we the undersigned jointly request your office to issue mail order against Advocate Tai Shiva / Tamu, presently residing at Leha Village, POPS Doimuk, Papumpara district. Sir, the matter before you is in that in 2019, Advocate Tai Shiva Tamu cheated with fraudulent manner and manipulation and lured 15 lakhs rupees from the above mentioned person, so and so, in promise of taking our highway compensation issue in the court of law as per jurisdiction available. Also, he gave us assured guarantee that the court judgment will come within 2 or 3 months, and he took money to door. As such case, the amount of respect is being so shared with public prosecutor. Sir, we have never hired or request Advocate Tai Shiva advocate to represent the case in the court, though telephone he called all the highway compensation victim and visit door to door, showed us provision bill in our highway compensation for Tam Tache 15 crore and Tam Losik rupees 20 crore without iota of truth, and started asking money 10% of his intention or cheating and manipulation, fraud, and to lure the money. He has never filed any case anywhere in the court of Arunachal Pradesh. We have been duped lakh 2 rupees by literate person who is legal petitioner. Instead of guiding us, he is looting. Since we cannot battle in the court of justice, we cannot afford legal fee to advocate and have knowledge of law. We want to solve the above matter as per customary practice or of our Nishi clan. Easier to all person to appear before Gabula, since Advocate Tai Shiva Tamo also help from the Sangram circle. Hence, the matter before the Gabura is easy and accessible. Therefore, as an innocent illiterate person, we request your office to issue mail order in the above cited subject, since all the victims.
Thereafter, this order was passed,
Yes,
organizing
This was
calling
the-
for a mail.
this was the allegation level to the petitioner.
But it was in 2023 itself.
Yes,
Thereafter, nothing has happened.
Subsequent to this complaint, a mail order was issued on the 28th to 2023, which is in page number 68. Lots of have already gone through this.
So it will be a civil matter or a criminal matter. It has been registered as a criminal petition only.
Yes, according to
Criminal petition
this
only.
forum is also Lordship, all Sangram Circle Gaumura Welfare Association. I think this welfare association is only for Gaumura within under themselves.
Mhm.
This cannot conduct ML, Lordship,
That has to be seen. As per you have to guide me because of
Lordship.
this local laws. Who are the respondents?
Respondents are Respondent number 3 is the president who has issued this mail order. 1 and 2 is the who has compiled the complaint before the respondent number 3.
Let me see the previous order statement.
That's it.
Frontier regulation, Sarma, frontier regulation. 1940. Oh, it was, oh, I see, it was, since 23 is pending, it's been stayed. It's
Yes,
become
Lordship.
irrelevant actually, almost.
Yes, Lordship.
This is all pending from then only.
But it stayed on 13 March 2023, Lordship.
The interim orders there, but steps are. Anyone from the prosecution side is there. You can assist the court perhaps, I'll be grateful. Can we proceed as a criminal matter?
I think it's.
Because, yeah, appears to be a, he's agreed by his, the calling of the mail.
Yes. So create actually civil matter.
Okay. I think it should be 227.
If it is the association that has called it, my lord, I think, my lord, the petitioner has a case. Because in terms of the 1945 regulation, my lord, Gaopuras are appointed as members of the village authority.
Hmm.
They are appointed for a particular.
Hmm.
So, my lord, say, supposing Naharlagan is a village, the village authority will be appointed for Naharlagan, they will exercise jurisdiction over it. The association itself, my lord,
They don't have locus standi. They don't have locus. Yeah, maybe. So it was rightly stated, perhaps, but it's been, might have almost become, as I said, kind of infractious, long time. Yes, sir.
I didn't know, so I didn't know.
Okay, no problem. You locate that decision. What we'll do is that you will just adjourn it for a few days, and you just look up the matter, whether if it is a civil revision, then it can be converted, or you withdraw and file afresh. That will be better. You withdraw and file afresh as a civil revision, right? As a 227 matter, and locate that law also, and the stay will have to continue. But why is this service taking so long? How is this taking ages? Okay. Heard?
Lordship, B. Kamdak.
Yes, sir. The petitioner is also, he's also a counsel, right? He's also.
Lordship, yes.
Learned, he's not a petitioner. Learned counsel for the petitioner. Perused the order dated 13/3/2023. The petitioner is aggrieved by mail MEL italics. Mail order dated 28/2/2023 bearing number so and so issued by the village authority. That you will find in this order 13/3, right? Good stuff. It remains to be seen as to whether this matter shall proceed as a criminal petition as has been registered as or whether the grievance of the petitioner has to be ventilated through a petition under Article 226 of the Constitution of India. As per order dated 13/3/2023, further proceedings of the mail pending before the All Sangram Circle Gaonbura Welfare Association was stayed. 3 respondents have been implemented. Steps are complete on whom? Steps also. as reflected in the order dated 6/8/2024. Service in respect of respond number 3 is complete. Unnecessarily pending, I think, this matter, no? So it should be disposed of. No, service is not complete. Respond number 1 and 2. The service is complete, it's mentioned again. Mhm. Yes. It is reflected in office note dated 39/2024 that though service report is complete, service is completed upon respond number 1, 2, 3. No wakalatnama has been filed on behalf of the said respondents. Have they appeared?
No,
No,
the
petitioner counsel submits that the respondents have not appeared. That's very strange. Why? That's very strange. You do that. You look out the provision,
that's
whether it will proceed in which direction,
that's it.
and look up the law also. But we have to proceed without them. If the service is complete, then we have to proceed without them. List the matter after 2 weeks.
2 weeks. Deeply obliged. Lots of interim.
The interim order dated the same, that order, that date. 13/3/23 shall continue till the next date of this thing.
Deeply obliged.
Let this remain here.
Item number 4.
This you need, sir. You need this back. It's important to know. This is. Item 4. Okay, civil revision.
There's a dispute between the petitioner and the respondents
Mhm.
regarding title of the land. So we approached the civil court.
Right.
Civil court took cognizance, issued notice. Thereafter, my lord, they approached the village authority.
I see.
And the village authority had entered a judgment. That is what.
While the civil matter was pending.
In fact, this petition was in fact allowed, my lord. There was some observation by this honorable court. So, some observation by this honorable court, who went on review, my lord. So that is how it has again come back.
I see. It's a review matter.
No, my lord, we went on review, was restored back to file again.
Let me see.
In fact, it was allowed.
To understand this matter. Let me see. I'll just go through it. Go through the order. Okay, so far so good. So it was civil suit was filed a few days earlier, and then this.
The same order can be passed. They have not been contesting it.
Okay, in view of the aforesaid, you will read it.
Provided the improved order dated such such shall not be implemented in the final decision.
Okay,
So this part where I did this we went on. So what it meant was some, depending on what the title should be decided.
Mhm.
The Kebab,
you are the petition, plaintiff in the title suit, plaintiff in the title suit. So you are agreed by the fact that this decision should not be implemented.
yes,
But you have sought the same relief in the title suit, isn't it? If you are the plaintiff.
yes, yes,
Right,
yes.
okay.
The Kebab decision, the only, security already allowed once. But there was an observation that, till the decision of in the title suit,
Mhm.
the Kebab came in heaven, meaning that it will automatically come into force depending on the decision of the title suit. That part were agreed, madam.
Mhm.
So that was only if your lordship,
The review was filed.
yeah,
And then what happened to the review?
review was allowed. Review is also there on the record, but I'm sorry to bring the order.
Review was allowed. Then this petition has come to be filed.
Come back again. No, it was already there.
I see.
It is restored to file. The review order is dated by the 7/1/2025.
Any page number?
The review petition, madam. That's the record, the review petition. Review petition.
This is the title suit record.
There.
Disposed of review petition.
Yes. Seven one twenty.
Yes. Judgment. Yes, para 11 is there. You have the record. Review, you don't have the. Para 11 coming to the hands. The grounds taken into civil revision as well as the window was not placed at the time organ have such grounds is specifically pleaded in the petition. Therefore, it's correct in submitting. Therefore, it was not considered by the person doing it. There has been given order. In the television, the company not in the. No, such. Accordingly, it was restored.
So
There
the same order can be passed, the earlier order, only excluding the part regarding implementation It's on the Kabang decision.
Mhm.
Or the Kabang decision may be, village decision, the village authority may be simply sufficient.
What about the other side?
They have not been representing earlier also. Their names are on record. They have never.
Which I'm picking up for the first time, just, it's not right. Hmm. No, the entire order was recalled, which observed that the.
Because of the observation
Mhm.
that the decision of the Kabang
Mhm.
should not be implemented by law till the decision of the Packers.
Mhm.
But that created difficulty for us.
Mhm.
In the event that should goes against us, the Kabang should could automatically be implemented.
Mhm.
The Kabang was against us.
Mhm.
That is why we went for it.
I see.
So the Kabang apparently was without being subject, that simply be set aside, but without any further offense.
Service is complete, right?
Yes, yes, my lord.
Long-
In fact, two councils earlier appeared, my lord.
None appears. Name of the decision.
Everybody
Selected
appears.
cost, considering what the cost. Objection. No objection also fine.
Yeah.
Office. Just taking it. 12/9 office note dated 12/9. Shift. It's been pending for now. Objection not yet filed on behalf of respondent. Only two respondents, right? They have not filed any objection also. That means that. I'm just checking the office note regarding completion of service. Must have been.
That's all.
No, no, should be.
The other response.
Mhm. Okay. Okay. Office note dated 26/4. But they have not appeared. So you propose that it should be disposed of
Yes. but
by setting aside that.
dispose of articles. When it's ordered, I have found it in fact.
Should we refer to any case law or not necessary?
Simple case, my lord, that was already, my lord, that is progress. Then there are, who objected to the written objections that.
Okay. We don't wait for them then.
In fact, there are subsequent developments in the title suit.
Long time, they filed it in April 2023, Wakalatnama.
Also passed in our favor.
Hmm.
They know about this matter. Okay, they cannot suspend in breakfast at all.
You're Mr. Pang. Shall we start? Huh? Yeah. This order is there actually. You can just the same.
It's almost the same.
Yes, you just you don't need to dictate. Order dated 25/4/2020. First three paragraphs will be the same. Two respondents have been impleaded in this civil revision petition. And notice was issued to them. And as per office note dated 26/4/2023. You can have a seat. 26/4/2023. Wakalatnama has been filed by learned counsels on behalf of the said two respondents. However, upon perusing the case record and the order sheets, I find that the respondents have remained unrepresented in the subsequent dates. Today also, the two respondents have not appeared. Before proceeding further, the background facts may be stated in a nutshell. As already mentioned above, the fundamental ground of challenge of the revision petitioners was that the concerned Kebang did not have the jurisdiction to pass the impugned order dated 12/4/2023 in the context of the pendency of TS title suit number 8/2023 before the learned civil judge senior division, right? With Pasika. Stop. The civil suit was also filed seeking the reliefs of declaration of right title and interest, along with consequential reliefs of permanent injunction over the suit land. The petitioner herein is also stated to be the plaintiff in the suit before the learned civil court. The civil revision, the incident civil revision was earlier disposed of by this court by order dated 12/4/2023, holding that as the title suit was preferred earlier in point of time, then the proceeding before the Kebang. Therefore, the Kebang would not have the jurisdiction to proceed with the matter. And therefore, let us go back to that order, which is in this file. It's order dated
25/10/2020.
Earlier in point of time. What is the last word I said? Oh, yeah. Therefore, if the Kebang proceedings allowed to go ahead, there may be overlapping of jurisdiction and conflicting decision. Accordingly, in para 8 of the said order dated 25/10/2024, 25/10/2025, it was directed that the order dated 12/4/2023 passed by the Kebang of GB Seram shall not be implemented till final decision is made in the title suit, and the same shall be subject to the decision of the civil court. The petitioner was agreed by this direction that the final decision that the order passed by the Kebang would not be implemented till the outcome of the civil suit, till adjudication of the civil suit, and filed a review petition for recalling the order in the context of that observation. After hearing the parties, The review petition registered as review petition number 10 of 2024 was disposed of by order dated 7/1/2025, recalling the said order dated 25/10/2024, passed in CRP 17 of 2017, which is that is the instant criminal civil revision. Full stop. And the present civil revision was restored to file. Full stop. In the aforesaid backdrop, the civil revision, instant civil revision, being the said restored CRP 17 of 2023, has come up before this court for adjudication. As already mentioned earlier, despite completion of service and filing of wakalatnama, the respondents have not been appearing. Stop. And today also they have not appeared. Full stop. The learned petitioner counsel submits that perhaps it would be prudent to set aside the decision of the Kebang, as it is untenable in view of as it was untenable at the time of being passed due to the fact that the title suit was already pending before the learned civil court. Full stop. That would do for the purpose. We need not go into so much details. We cannot go into the civil dispute. It's not our jurisdiction. And please add there.
Why don't we simply say the Kabang sent that 12/4?
12/4/23. I've given my consideration to the matter, semicolon, perused the relevant materials, and considered the submission of the learned counsel for the petitioner. Full stop. Since the respondent side has not been appearing despite being noticed, and the matter pertains to 2023 with an earlier, with a background of earlier round of litigation, therefore, it may not be justified to keep it pending, and it would be proper to dispose it off at this stage. The facts and from the facts and circumstances which have emerged, it is clear that let us reflect this exact order which was passed by this court. What was the first order you had shown me when the court had reflected the two dates, the date of the Kebang and
Yes, the suit was registered on 6/4/2023.
it is revealed from the materials that and as also reflected in the earlier order of this court dated 25/10. It is reflected there. Check it again. I saw it. Just I think this one. Yes.
It's in the paragraph 4.
Oh yes, this one. I was seeing from this one. Yes. Full stop. I will correct, fine tune it. It is in the aforementioned order dated 25/10/2024, passed by this court. It is stated in para 4 that the title suit was registered on 6/4/2023, and the Kebang decision came to be passed on 12/4/23, and therefore the court held that as the title suit was filed and was pending at the time of the Kebang decision, the same cannot be allowed to proceed. Stop. And the civil court has jurisdiction in these matters now as per the
Yes,
law?
yes. But there have been many subsequent developments. Injunction also part in our.
Yes. In the given facts and circumstances and the admitted petitions emerging as aforesaid. Stuff. I find force in the contention of the petitioner side that the Kebang decision can be interfered with at this stage while allowing the title suit to proceed. Stuff. In such view of the matter, the order dated 12/4
Yes, 2020.
2023 passed by the
Sabah.
this no Mongo Bango.
Yes. Just a moment.
Yes, MONGGU
Bango Kabang.
Ongo Kebang decision
The petition 420.
is set aside, interfered with and set aside. Full stop. Needless to say that the titles, the Court of the Learned Civil Judge Senior Division Pasigat, which is adjudicating title suit number
Eight.
Title suit number
8
8 of 2023 can continue proceeding with the said civil litigation. Full stop. The civil revision stands allowed and disposed of on aforesaid. Fine, no issues.
Item number 5,
Any records from work court? No. Scan copies.
scan copy.
May I please, Your Lordship?
Yeah.
Your Lordship,
Yes.
this is an application under section 482 of the CRPC, Your Lordship, praying for quashing of and setting aside of the order dated 30/8/2023, passed by the learned CJM Bomdila in CR case number 8 of 2017, Your Lordship. Your
Okay.
Lordship, we also prayed for allowing the petitioner to adduce defense witness in the said case, which was rejected by the both CJM Bomdila and subsequently by the additional district and session judge Bomdila, Your Lordship.
Nice.
Your Lordship, in this case, already we have taken so many steps, even in the IA and in the main petition, Lordship, but till today, none of the respondent has not turned up, Your Lordship. And
Yes,
because
I
of
think
that,
state will
already
be a
we have
party.
only
in this,
one sole respondent, Your Lordship. We have
Just-
taken
just a
justice service as well.
I'll have a look. Impugn order, I'll just have a look at the impugn order. That is a page
14, Your Lordship. Oh, sorry, Your Lordship. It says
14?
16, Your Lordship. 16.
16.
16, Your Lordship. In the main impugn order is at page 16, Your Lordship, which is passed
yes,
by
I got got it. Okay. So on the third date, it was rejected, right?
Yes, Your Lordship.
Then you preferred a revision before the sessions court.
Yes, Your
Oh,
Lordship, which is at page 18, Your Lordship. Impugn order is at page 18, Your Lordship.
Okay, now, so this is the. Thanks. So after that, after the dismissal of the revision, this criminal petition has been filed, right?
Yes, Your Lordship. Your Lordship, the petitioner's intention was, absent was not intentional, which is beyond his capacity, Your Lordship, as his engaged counsel was appointed as the Chief Legal Defense Counsel just previously. And for that reason, when he appeared before the, approached the court on 30th of 2023, he could not proceed with the case. And it was very short time to engage with some other lawyer also, but it was not allowed to proceed, and subsequently this impugn order
Only
has
problem,
been.
yeah, the only problem is that it's an old case, 23
Yes,
case,
sir.
you know, but
Yes,
check
Your
bouncing,
Lordship.
not so old, but
Yes, Your Lordship.
not speaks for dependency. He was appointed LADC.
Yes, Your Lordship. Yes, Your Lordship, which is attached as Annexure 1 and in the page number 14 and 15, Your Lordship.
Otherwise, you know, there's not much informity in this thing, and one for say, the learned court has also referred to. Can you give me this enact? Yes, we all know that the accused has to give a request in writing, right? Under 315 CRPC, the earlier one. So
Yes.
one of he also wanted to examine himself, the accused, in
Already,
this case.
3-1, already he was examined on, Your Lordship, on
No,
28.
not 311, man, not 311. No, not 313. Sorry. As a defense witness, if the accused wants to examine himself as a
Yes.
defense witness, he has
Yes,
to
Your
he
Lordship.
has to give a request in writing.
Yes, Your
Own
Lordship.
request in writing. That has not
Yes.
been given. That was not given. No,
That was
this is enact. That's okay. No, you don't need this. 142.5. Otherwise, there's no informity actually. I think trial can proceed. It's almost complete.
Your Lordship, he has sufficient materials to prove his case, and which is also been attached along with the criminal petition, Your Lordship, as Annexure 5 and 6, how his check has been misused by the respondent, Your Lordship. And that's it's very much required to prove in the court of law, Your Lordship, and that's why he requests for an opportunity to submit his defense witness, Your Lordship.
I think he's rightly said. He said that this under defense witness can also be given on affidavit, but no such application or affidavit was submitted. But of course, that would come only when this is allowed, right?
Yes.
So that no affidavit was filed. Secondly, the revisional court said that under 315 CRPC, it is right actually that if the accused wants to examine himself as a defense witness, written request has to be given. The reason for that is that there are some checks and balances.
Yes,
There are some checks that he's only on his own written request. The accused can adduce evidence as defense witness.
Yes, Your
So
Lordship.
otherwise, there's no major infirmity in the decision. But if the petitioner,
And
then
for
we can
that
remand
reason
it back,
only
and then you submit an application under 315 then, and
Yes, Your
to
Lordship.
examine yourself within
Yes,
a
Your
limited
Lordship, that
time,
will-
right?
Yes, Your
Oh.
Lordship, that will be highly obliged.
But
if it is
just checking the service is complete, right? Because nobody has
Yes,
appeared.
Yes, Your
Because while
Lordship.
dictating, I have to write that.
Yes,
It
Your
is
Lordship.
free.
So justice service has also, we have submitted an affidavit has also been submitted before this honorable court with that regard.
Dusty service was given.
Yes,
Justice-
yes, Your Lordship.
Your lordship, sorry, the,
State is also there.
yeah, yes, this is item 12. My learned colleague was endorsed in this case. He is not present today.
12, this is not 12, I think. This is different matter.
Right.
This is 5.
Yes, next, that may be.
Okay. Don't worry. Let me finish this. The proceedings are under stay.
This is an admission column. Meta may be admitted and meta may be taken up.
Just a minute. Okay, one Dusty affidavit was filed, but it was not accepted by the court, right? So again,
Yes,
the
it
last
was-
order it was last order dated 25/7/2025. You had undertaken to take fresh steps by registered as well
Yes,
as
yes.
Dusty. Thereafter, I believe the affidavit has been filed. Thereafter,
Yes,
probably it
yes,
was
Your-
filed.
Yes, Your Lordship, that has been filed.
Your lordship, in criminal matter, there shall not be a dusty service because there is a likelihood of some threatening and intimidations.
That's true.
It should be
It's a complaint.
served through
It was allowed once, and it was allowed twice, in fact.
jurisdiction police station.
That is, you have a point, but anyway, let us see. Otherwise, it will remain stuck at the stage of service.
Yes, Your Lordship.
Service report noted received in respect of respondent one. Service report awaited. Council has taken first steps for service of notice. Respondent number 1. Nope, this is okay, this is sufficient. Sufficient.
Oblajo.
So it's been pending, we should dispose it of. No?
Yes.
Okay. Here also we can take advantage of this order. Just passed earlier, we can take the details. Heard MDECA, Learned Council, for the petitioner appearing through the online mode. None appears on behalf of the sole respondent. Order dated 21/12/2023. Take for the second paragraph. Okay. Due to non-completion of service upon the sole respondent, this court earlier had told the petitioner to take service by dusty mode, and as reflected and by the order dated 21/1/2025, though the compliance affidavit was filed, but due to non-narration of certain details, the said affidavit was not accepted. Subsequently, by the order dated 25/7/2025, the petitioner was allowed to take fresh steps by registered post as well as dusty service and submit compliance affidavit. As reflected in the office note dated 21/8/2025, the compliance affidavit regarding such dusty service upon the sole respondent was filed. Peruse the said affidavit, which states that the notice was received by the proprietor Tage Lapung of MSTL Construction on 17/8/2025. Copy of the receipt has also been annexed and I have perused. Therefore, the service can be taken to be completed. 17/8, right? Considerable time has elapsed from the said date of 17 August 2025. But the sole respondent has not appeared. Therefore, full stop. The petitioner who as accused is facing the trial in CR case number 8/2017 before the learned CJM Bomdila sought to adduce defense evidence, and the same was rejected by the order dated 30/8/2023 by the learned magistrate, as earlier 2 dates had already elapsed for reducing of such evidence. The said order was taken up in criminal revision to the learned session judge West Kameng, sessions division, division of the session judge comprising the district of West Kameng, East Kameng, and Tawang, in criminal revision number 1/2023. The revisional court concurred with the order of the learned trial court and upheld the same, observing that the petitioner as accused had not filed any affidavit before the learned court below in terms of section 145 subsection 2 of the Negotiable Instruments Act 1881 within bracket NI Act. It is also observed by the learned revisional court that as per the statutory provision under section 315 CRPC within bracket, as it existed then and presently ... section ... BNSS, if an accused desires to examine himself as evidence as witness in a trial, he has to give a written request he has to give a request in writing. It is submitted by the learned petitioner counsel that the petitioner as accused wanted to adduce defense evidence in the form of important materials and documents regarding misuse of the check, and that since he is facing a criminal prosecution, depriving him from adducing defense evidence would cause him substantial prejudice. Full stop. Where are the documents you had mentioned? You had mentioned some documents.
Yes, Your
Is
Lordship.
annexed? Is it
Yes, Your
annexed?
Lordship. Yes, Your Lordship. Annexure 5, Your Lordship.
Annexure
Which
5.
is the intimation, yeah, and Annexure 6, Your Lordship, which is at page 24 and 28, Lordship.
Annexure 5 and 6.
Yes, sir. Annexure 5 is regarding his loss of his check, which was intimated to the bank, and the status report.
The learned counsel has drawn the attention of this court to Annexure 4, right? Oh no, and Annexure 5.
6.
Annexure 5 and Annexure 6. Annexure 5 is a letter dated 17/6/2017, purportedly written by him to the branch manager of Central Bank of India regarding loss of check bearing number 020639. Stop.
Your Lordship, I beg to apologize. Here, state is not a part. State is not a part.
It is not a part. State is not a part. So it was intimated to you that it wasn't stopped pursuant to your application, right?
Yes, Your Lordship. Yes, Your Lordship.
Stop. It is also submitted, and it is also revealed from the materials that the counsel, who was earlier representing the petitioner, was appointed as a chief LADC, legal aid defense counsel, and it is contended in this context that therefore there was miscommunication and failure to take steps, resulting in the impugned order, resulting in delay in adducing the defense evidence. In the entire facts and circumstances, I deem it fit to give an opportunity to the petitioner to adduce defense evidence without, however, delaying the trial. Accordingly, the impugned order dated so and so is hereby interfered with and set aside. The petitioner is accused is at liberty, prefer an application under section ... BNSS for examining himself as a witness, He shall also submit before the court the list of witnesses which he desires to examine as DWs on his behalf. Thereafter, the learned trial court shall pass necessary orders as per law. to ensure that within a reasonable time, it can be done. To ensure that the matter is not delayed for DW, for defense with evidence. It is directed that the learned trial courts shall endeavor, you make the word endeavor bold. I am not giving a mandatory direction. Shall endeavor to complete the stage of defense evidence within a period of 2 months or 3 months?
Yes, Your Lordship.
2 months?
2
2
months,
months? 2 months will do, I think. Within a period of 2 months. The instant criminal petition stands allowed and disposed of on the aforesaid terms, right?
Yes,
If I missed something, I'll correct.
Yes, there.
What was the IA for? The order of stay granted by the order dated so and so, dot, stands vacated. IA is for what?
No, there.
She is logged out. Nice. No, actually, she will log in again. She also forgot about it, perhaps.
Your Lordship,
Stay
Your Lordship, there are,
State the
IA
proceedings. IA is disposed of, I think.
yes, Lordship.
Disposed of because stay was granted, right? So stay is vacated now, so that the proceeding can go ahead. That's okay. It is disposed of. It's disposed of. It's silent. So,
Item number 10.
10.
Item 10, there was legal aid counsel was appointed.
Legal aid counsel, yes.
She is absent today.
Jairam.
Yes, NT Jairam.
H. Jairam. There's a delay of 263 days.
Your Worship, kindly pardon me. I don't have a brief.
No,
I'm representing otherwise.
no,
the-
no, it's okay. Problem. You have to see the facts. You'll be able to submit.
This is something like jail appeal.
Jail appeal.
Yes, that can be condoned because that is
That's what I was thinking.
yes, it's totally right.
Jail appeal against conviction,
Yes.
so no problem. By order,
Delay can be condoned.
there is an order. By order dated 26/9/24, the appellant was asked to file an appropriate application for condonation of it.
Yes.
So that is why it is.
Some formality has to be done, Your Worship. Otherwise, delay has to be condoned
Yes,
because
I
there is a jail.
would have passed.
I'll inform her to the legal aid counsel. Next, that may be kindly fix.
Paper book has not been prepared.
In single page, sometimes it not necessary to paper
Now,
paper book.
nowadays, it's very convenient if paper book is prepared, but
Yes.
yes, nowadays, the depositions are typed. So we may be able to manage.
Yes.
We can-
Your direction may be
NDPS, right? This is NDPS. So, but the paper book undoubtedly helps. If we are getting some time, then we can take a chance. maybe.
yes.
No, it has been condoned. It has been condoned already.
Yes.
Criminal appeal, the appellant is being represented in this case. Criminal appeal, 20.
My lord, earlier there was a direction, but later on it was condoned because she's appearing for
As a
the-
legal aid counsel.
as a legal aid counsel, so she find difficulty to go to the
Yes, yes, no,
jail authority. So for that, it was condoned. However, your lordship, TCR not received.
TCR not received. And so since we are getting some time, we can take a chance with preparing the paper book.
Yes, my lord.
I've seen here very nice paper books.
Yes, my lord, absolutely. Even I will prefer paper book, my lord, because there is a variation in the page number. Otherwise, if we
Very,
go
very
for the
convenient.
yes, your lordship.
All appeals, no, civil also,
Yes, my lord.
you know, it really helps the adjudication,
Yes, my lord.
you know, really lessens the chance of mistakes.
Yes,
Become-
absolutely. my lord.
Becomes very systematic. Anyways, so the appellant who has preferred this appeal from jail is represented in this case by learned legal aid counsel, Ms. H. Jairam. However, today she is not present. Learned additional public prosecutor, Mr. So-and-so appears on behalf of the state. Peruse the order dated 6/5/2025. There was a delay of I just saw the order. There was a delay of so-and-so days, it was considerable delay, 600, 300,
263 days.
263 days in preferring the appeal from jail, which however was condoned by the said order dated 6/5/2025. The appeal has already been admitted. And though TCR has been called for, TCR of special NDPS case number 1 of 2019 was called for from the Court of the Learned Session Judge Pasigat. However, it has not yet been received. Issue reminder for the scan, we don't need the scan, it's original comes
Original, my lord.
for the TCR. In the meantime, a paper book may be prepared, full stop.
Your lordship, after receipt of the LCR.
Yes, yes,
Yes,
and they can,
yes.
they'll need that. Nothing else, done. It's a conviction on the NDPS Act. The appellant was convicted and sentenced under section 20 within bracket capital A /21 small b of the NDPS Act 1985. Leaves the matter after so and so weeks in the orders column.
Yes, ma'am.
After
Preparation of paper book.
4 weeks.
Okay, your lordship.
After 4 weeks.
Obliged.
Kindly inform Ms. Nav.
Yes, yes, ma'am.
She may have missed it today.
Item number 11.
Yes, my lord. Here has error, my lord.
Yeah, just
Yes.
TCR. This item 11, right?
11.
11. File. Just. Oh, so okay, we take. Can we take it up after some time? The file is just inadvertently went to the PS room. Just wait here. We'll take it up after some time. Moment it comes.
Item number 13.
No problem.
May I lose? I'm for the petitioner and this present case is for the quashing of FIR on merit. And then since service report on respondent number 2 is awaited.
Okay.
So-
Is it a POXO matter?
No, Your-
It's wrong. It's respond number 2. Yeah.
As per office note, service report is awaited.
Arunachal Pradesh. It's Omen Taki, right? Informant. Stood under section 379.
yes,
Why, you're seeking quashing of the FIR.
yes.
Okay, so let us, we'll wait for the service.
Close.
Heard, Mr.
N. Ruza.
The learned counsel for the petitioner, who's seeking quashing of a charge sheet, the FIR number, FIR giving rise to Itanagar,
Yes,
PS case number 149 of 24,
yes.
under section 379/34 IPC. The informant has been impleaded as respondent number 2. However, service steps of service though taken, the same is not complete. Shall we await or express service will take? We'll await.
Yes.
There's no interim order, right?
No, no.
So you can. We'll wait then.
Right, so we'll wait for service to be complete.
The service upon respondent number 2 maybe await. This is the matter. After, we can take a chance after this 25 matter, no? After 3 weeks. After 3 weeks.
I love.
Leave
In
reply.
the orders column.
Item number 11.
14, whatever, 14. 14. What's this timing? Orders come, no? Okay, please come now. The criminal petition.
This is a joint application for crossing of the crossing and setting of the FI 30220 and the charge sheet number 07. That's 073/2022 corresponding to Basar PS case number 01/2020.
Okay.
Your Honor, that the petitioner number 1 and the petitioner number 3 had a relationship. Due to some temperamental differences, petitioner number 1 uploaded one nude video. Thereafter, he immediately deleted that one. So, my lord, thereafter, the petitioner number 1, 2, and 3 come into compromise and enter into
That video was taken down.
no, ma'am.
No, it was deleted.
Yes, yes. After executing deed of compromise, my lord, petitioner number 2 and 3 forgive the petitioner number 1, ma'am.
Yes. You are appearing? Ms. Hagi, you are appearing? This matter. Record has come.
Your Lordship, additional PPT attached appearing. I'll just call him Lordship.
Who is the father of the girl?
Yes, ma'am. Father of the petitioner number 2.
Oh, it's 1 o'clock. This has come up for orders, no? Are you
Yes, ma'am.
seeking disposal at this stage?
Including my lord, it may be disposed.
Just hold on. In a relationship, initially settle the differences. Secure 15.
It's in joint petition. It's in joint petition.
Hmm?
Since joint petition.
Joint petition.
They have component, the non-component.
Hmm.
Compromise is that. Some settlement is also there.
You'll do one thing, I think, take it up at 2 o'clock. Huh? Then in the meantime, I'll just go through it. Yes, I'll go through it in the meantime and then you can, yeah. Also, you can also submit. We can dispose of, maybe we can dispose of it. No, this actually this from just generally speaking, because law is there to protect you. It must be there. The legal regime to protect this kind of uploading of personal photographs has to be very strict. And it's there. But at the same time, in today's times, we all of us should also be careful ourselves. We should also be careful ourselves also. Don't should not take photographs like that. Should be careful, and there should be a mechanism for the police that anything is there, it should be taken down immediately, right? So many incidents like this happen nowadays. Anyway, at 2 we'll try to dispose it off. So I just glanced through it. Well, since both have joined, so we can dispose it off perhaps. But today it has come for orders, however.
If your lordship, the records are available.
Records are come.
Yes, it's up to your lordship whether your lordship. Because initially what has happened in this case, it was registered under section 294 sub.
Yeah, that is the Orissa High Court.
Yes, and
That's why I said.
and
That's why
second-
I thought now 298 is not.
Yeah, and second is 67A of the IT Act, my lord.
Mm.
And the charge sheet was not filed under 67A of IT.
Only
Act.
290.
Only 290, and that's too not applicable in the state of AP. So later on, considering that aspect, this honorable court has initially stayed the proceeding, but direct them to appear before the learned trial court and make a proper make argument on framing of charge. So
Yes, if the case proceeds or had proceeded, then that aspect could have been corrected at the stage of framing of charge.
yes. Now it has been corrected, my lord. Now it has been charged under 294 and 67 of the IT Act.
294 and 67 of the IT Act.
Yes, madam.
Charge has
292 of IPC and 67 capital A of IT Act 2000.
That is the charge.
Yes, my lord.
Charge has
Charge
been-
frame, yes.
Charge frame.
Yes, my lord.
And for prosecution witnesses also examined.
My lord, no, the death is initially it was fixed on 1/5
But
of
state,
20.
state.
Yes, madam.
Okay.
Now they have already settled the matter.
Can the consent of the girl or the informant side can be ascertained from the fact that they are joining the petition?
Yes, my
Or
lord.
you need to take any instructions regarding?
No, my lord, this agreement itself disclose everything. My lord, will find in page number 29 and 28 is a translated copy. My lord, 29 is it's a local dialect one. It was translated.
No,
and-
I've seen that.
Yes, yes.
Okay.
Yes, our only effort would be, your lordship, that to restrain him from further disseminate that video, my lord, because.
No, that's why I said that.
Yes, my lord.
First concern in matters like this is this.
Yes, my lord.
Because it can lead to bigger tragedies.
Yes, my lord, because I
Like
come across the
suicide.
judgment of the Delhi High Court,
Yeah.
wherein the POCSO matter was involved, wherein the photographs has been circulated, and the boy has extorted a certain amount from the girl. So later on, they compromise and they approach this honorable High Court, and High Court, by imposing certain condition, has quashed the matter, madam.
Okay.
And
You have the judgment.
Yes, madam, I have the judgment.
But in this particular case, that WhatsApp, it was on WhatsApp.
Yes, my lord, but video.
It has been deleted.
Yes. So they have to undertake that it shouldn't be further de-assimilated. My lord, you'll find in para 13, my lord.
Yes, these conditions have been given.
Yes, my lord. My lord, may
With the
13.
following directions.
Yes,
Commissioner
but
Sami.
my lord, it's 13.1. FIR number so and so is quashed. The petitioner shall remain bound by the terms of the settlement as well as the undertaking punished before this court. In the event that the aforementioned photographs resurface in any form or medium, the complainant shall be at liberty to seek revival of the FIR and pursue such remedies as available in the law. This is one of the condition, my lord. And cost was also imposed and further directed for my lord,
Community
community service. Yes, your lord. Now BNSS recognized community
That's true.
service.
That is true. That is true. But that is as a punishment, actually.
Yes, my lord.
Community service is also a punishment.
Yes, yes, it's a punishment for the lesser offense.
That's true. But
Yes.
can it be imposed? Can a punishment be imposed as a
No, no, but without
condition of a
trial.
quashing?
Yes, my lord.
Right.
Oh, absolutely. That is distinguishable from, as your lordship has rightly
Some
pointed
kind
out.
of service as part of a convict undergoing sentence is another matter.
Yes, my lord.
That's another matter.
Yes, my lord.
But since community service is now one of the penal,
Yes, penal
sentences.
for your
Would it
lordship.
be,
less
would it
punishment.
would it be fair to make it a bail condition, or will it be fair to make it a condition of quashing?
Yes, yes.
I'm not sure.
Yes,
So
I'm not,
anyway,
your lordship,
it was a
pressing
Supreme
on that.
Court decision. Of course, we are bound by it.
Yes, yes.
There can be,
And I'm just referring that 13.1.
fine, but it's an interesting concept.
Yes, madam.
It's an interesting concept, as a condition of quashing.
Yes, madam.
Inherent powers can
Yes.
be used.
Here, my lord, if we see, my lord, one aspect is there. They have admitted
Hmm.
that, yes, this thing has done by me. So I will not repeat it again. So they enter into an agreement.
Hmm.
So the scenario is totally different
Hmm.
because since it is a non-compoundable offense, my lord,
Hmm.
they have approached
True, true,
jointly under
true.
528. So
True.
that aspect is there.
Yes, yes.
They are not on merit, my lord.
Some cost can be imposed maybe,
Yes, madam.
or maybe not. This is an interesting order.
Yes, my lord.
It's an
I will
interesting
leave
order.
it to your
Suppose, as part of a quashing condition, suppose the High Court imposes a fine of 10,000
Yes.
fines.
Yes,
But fine is a punishment,
yes, madam.
that would be amounting to kind of
Yes, madam.
usurping the jurisdiction of trial court
Yes, madam.
in a way.
Yes.
Anyway, I'm not very sure about this, but
Yeah. And one more aspect is there for settlement, my lord, the Supreme Court recognized that even your lordship, 326, which is a causing voluntary, this, grievous hurt, my lord. Even in that case, my lord, Supreme Court recognized that if certain consideration has been, yes,
usually not, but
Yes.
Certain conditions, yes.
yes,
So I'll not, it's a very interesting, can I keep it?
yes, yes, madam.
But if you don't have a spare, then
But I have spare, madam. I just-
I will keep it.
I'm just, my lord, I'm just referring it, my lord. I'm not saying pressing that it should, the same order should be passed, my
No,
lord.
no, it's an interesting order.
Yes.
It's an interesting order, a very interesting order. Anyway, for our matter, we'll not go into this.
Yes, and it's
Just keep it,
distinguishable, my lord, because it's a POXO matter and his case is not a POXO one.
But these are also, this viraling of things are in the present times, which is happening.
Yes,
Very
ma'am.
disturbing. Learned Council will also agree. We are all doing our professional duty. I think professional duty, but these are, people should be responsible enough, everyone, not to do these things. As I said, these can lead to bigger tragedies.
Yes,
Like
ma'am.
suicide, etc.
Yes.
Anyway, please have a seat. I will dictate. It was our elaborate order already is there. Previous order is there. Ulta service written. Itupa we can take. No need to repeat this. First three paragraphs. You are Mr. Bogo of the Hanoi Land Council and additional people. Para 1 and 2 of the order dated 8/9/2023 would be same. Nah, switch slightly AC, AC. Feeling a little hot, stuffy. No, make it cooler, right? It's slightly. Though the case was registered under section 2292A of the IPC, but it came to be revealed that the same is not same has been inserted in the state of Orissa by an amendment, by a state amendment, and therefore not applicable in the state of Arunachal Pradesh. That's true. As already stated at the outset, that the FIR was lodged by the father or father. As already stated at the outset, the petitioner, who is the accused in the case, has filed his joint petition along with the informant as well as victim. Then By virtue of the joint petition, they're seeking quashing of the criminal proceedings. Full stop. In this context, the learned additional PP submits that the investigation of the case resulted in a charge sheet, and subsequently, the learned trial court has also framed charges against the accused petitioner, against the accused under section 292 IPC read with section 67A.
My lord, charge sheet was filed under 29, not the 67A, my lord.
Only, no, charge sheet was filed, no, charges.
Charges, my lord, yes, later it was framed, but so far a charge sheet is concerned. my
I know,
lord,
charge sheet
yes.
I have not mentioned the
Yes, 67A, my lord, IT Act.
67A of the Information Technology Act and section 292
Yes, my lord.
of the IPC. The agreement is at page, it was, the agreement was arrived at before Keba.
Yes, my lord. Yes,
Uh,
Page 29, my lord. Translated is in 28. Annexure 3.
the settlement arrived at between the parties before the Keba has been annexed as Annexure 3. And it is stated therein that on 27/3/2020, a family meeting was held regarding the case, during which the accused Marchi Gadi begged apology before the informant of the case and other family members, and promised not to repeat again in the near future. And that if he repeats the same, then the family would give him suitable punishment. It is also stated that in the context of this, in the context of the same, the informant and his family pardoned and forgave the accused, Marchi Gadi. The learned additional PP does not dispute the family settlement. The settlement arrived at family settlement. The settlement arrived at between the parties. Stop. Though the nature of the allegations in the FIR was was pertaining to uploading of some private photos, private video of the victim girl on WhatsApp. But it is submitted by the petitioner side that, and also revealed from the materials that the same was subsequently that was deleted soon after. In the given facts and circumstances, considering the settlement arrived at between the parties before the traditional forum, traditional and customary forum, I'm of the considered view that allowing the prosecution to proceed would be a futile exercise and a waste of valuable time of the criminal court. Full stop. Therefore, accepting the agreement between the parties and the prayer of the petitioners, especially the petitioner number 1, who is the accused in this case, the proceedings of what is the present case? Help me with the details. You have to go from the last. The proceeding of GR number so and so, resulting from charge sheet number so and so, arising out of
FIR dated
arising out of Basar PS
Yes.
case number
But
1
one
of
of
2020 shall stand washed.
Yes.
Full stop. We can impose some conditions in our own ways.
Yes, my lord. The first one, the further dissimulation, because
Yes, yes. The following conditions are imposed. Number one, the petitioner number 1/accused shall cooperate with the, shall abide by the process of law. Number two, he shall not in any manner harass or intimidate or harm or annoy the victim girl or her family. He shall not in any manner do any act which is detrimental to the dignity and privacy of the victim
yes,
and
it will
the
suffice.
victim and the family. The criminal petition stands disposed of on aforesaid time. See, one beautiful thing is this, there is a scan record, right?
Yes, ma'am.
Scan. One beautiful thing about these traditional systems, this can be very, very powerful. What I found is that the conditions, the spirit and the strength of the spirit of conditions is also there in that family settlement.
Yes, my lord.
Which was arrived at in a traditional forum.
Yes, yes, absolutely.
It is there.
Yes,
Conditions, they've imposed conditions.
Yes, ma'am.
There is a condition that he will be punished
Yes,
by the
yes.
family.
If again he
this is-
repeats something.
This is very good, actually.
Yes,
So it is there. In our own way, it is there.
yes, it's on.
So we have our own model.
Yes, yes.
So if necessary, we can always see this.
Yes,
But
ma'am.
this is an interesting thing,
Yes, ma'am.
order. We'll have a look. I'll just keep it.
Oblige, madam.
Item number 14. Just a minute. Video पर है, start video पर है. Item 114 lodge. This is a criminal appeal, jail appeal,
It's criminal matter, Lordship.
criminal matter.
Because last of it, Lordship, appeal memo already been served to the board parties, Lordship. Teacher may be called for, Lordship.
Sujit Das. Nice. Taba Tagum has been appointed
Lordship,
as a
yes, Lordship.
legal aid counsel,
Yes, Lordship.
amicus curiae. Two counsels are mentioned, Advocate Hagetai.
Lordship, in last occasion, Lordship, he just appeared, Lordship, yes, Lord, on behalf of him, Lordship.
Must be assisting.
Yes, Lordship, assisting, yes.
So I'll reflect both the names.
No, Lordship, only T. Tagum,
Amicus.
Lordship, yes.
Taba Tagum. No. Here's the order dated 18/6/2025. So has it been admitted?
Last occasion, Lordship, only appeal memo we have received, Lordship. It's not been admitted yet. Lordship.
Not yet. We can admit it.
Yes, Lordship.
As per office note dated 30/10/2025, Advocate Taba, learned counsel Taba Tagum has been appointed as amicus curiae. Pursuant to the direction of this court, by the aforesaid order dated 18/6/2025 to the Registrar cum Secretary of the High Court Legal Services Committee to appoint legal aid counsel. Full stop. The convict appellant was convicted in Bomdila Sessions case number 1 of 2023, arising out of Balemu PS case number 5 of 2022, under section 323, 342, 506, 392, 376 IPC, and sentenced to undergo. It's in the note. Should I dictate or write from Sibu? all the sentences were directed to run concurrently. You just take it from the High Court order and note. The appeal is admitted for hearing. Call for the PCR of. You have to cross-check once. Sessions case number 1 of 2023. From the court of the Bombilla will be which sessions court? Will be from the court of the session judge, West Kameng district.
Yes, Lordship.
There's a West Kameng, East Kameng, and Tawang, I
Is
think
it?
one sessions division,
Yes,
right?
Lordship.
No,
It's a different Lordship.
it is different now.
Separate Lordship.
And now it's separate. It will be West Kameng district.
Yes, Lordship.
From the court of the learned session judge, West Kameng district. Full stop. This is since 376 there is there, though it is a jail appeal, we have to note, we have to notice the informant side.
Lordship, yes,
But who will-
notice should be all of
Okay.
it,
Uh,
the informant.
But who will take the steps?
Lordship,
Amicus is there.
yes, Lordship, through, Amicus will take the step, Lordship.
Expenses
Expensive, Lordship, it.
can be reimbursed. What was this procedure? I've forgotten.
Lordship, here, Lordship, actually, the registry will do the needful, Lordship.
Okay. So we'll write like this one.
Yes.
Steps of notice may be taken upon, no, but it's not been implemented actually. Steps of notice shall be taken upon the informant. Registry shall do the need.
Yes, Lordship.
Then perhaps if then after the notice is complete, we can appoint amicus also for that. If-
Amicus, yes, for victims.
For,
yes,
for,
Lordship.
if the informant does not
Yes,
appear.
Lordship.
In the meantime, PCR is called of it. The paper book we can give it.
After receiving.
Yeah,
of
after
TCR,
receipt
Lordship.
of the TCR, a paper book may also be
Yes, Lordship.
prepared. It's very convenient. I've seen paper books are very good. I've seen here. The few I have handled are excellent.
Yes, list, Lordship, after
List after
3 weeks, Lordship, 3, 4 weeks,
at least 3 weeks will be necessary. 3 or 4 weeks.
4 weeks, Lordship. Then.
4 weeks. Yes, 25 I think.
Item number 15.
Is also criminal.
The learned PP was requested to seek instruction from the police as to whether service upon the
Oh.
complainant has been affected or not.
Mhm.
But, my lord, while laying my hands, I came across the division bench judgment of this honorable court, where in such cases, my lord, other than the offences prescribed, in POSCO and rape and other cases, my lord, then their participatory right is mandatory, giving notice to that.
Mhm.
But our division bench says in such cases, it is not mandatory. My lord. I have the judgment.
Mhm.
They said,
It's not mandatory.
Yes, not obligatory to.
Except, yeah, this,
rape and POSCO.
yeah, those are mandatory.
Yes.
It's not mandatory, but it may
But
be,
they have participatory right.
yeah.
My lord, except,
With the leave of this court, Lordship.
my lord, except
There's a very recent judgment of the honorable, no, I agree with you, you're
So-
correct. It is not mandatory is one thing, desirability is another. Nobody would disagree, prosecution will not disagree
my lord,
that it may be desirable, but it is not mandatory.
my lord, one of our single bench major observation is a must. So therefore, that section 301 was interpreted. Kindly come to para 20 straight. my lord.
Para?
Para 20 of this. The Justice Mirshaz Ali has laid down. In view of the discussions and the reasons stated above, we answer the question in negative. We further hold that it is not obligatory on the part of the accused or the court to implement the informant as a party or to serve the informants with notice before proceeding to hear an appeal filed by the accused conviction in a case arising out of a police report. However, the victim may participate with the permission of the court in the appeal filed by accused against conviction and may engage a counsel of his stroke her choice to assist the public prosecutor in charge of the case and may also submit written argument with the permission of the court. Therefore, in our opinion, the direction given in the criminal
appeal number so and so by learned single judge making implement of informant obligatory on the part of the appellant in an appeal preferred by the accused against conviction does not affect good law. The answer. So therefore, today I am pressing for the suspension of the sentence.
Yeah, it will be good to read this judgment along with that judgment of Nayak, where our High Court has said,
Nayak.
that in POXO and all these
Deepak Nayak.
cases.
Deepak
Deepak
Nayak.
Nayak. So these two has to be read together.
Yes.
And then we get the complete picture.
Yes.
Right. So Deepak Nayak says that in POXO, what is that? POXO and only POXO.
POXO
And the
and rape.
Rape cases, 376. They should be implemented.
Yes.
Implemented and noticed. And the division bench, though it came earlier point of time, but this holds the field.
Yes.
So this says that it is not mandatory.
yes.
So both have to be harmonized.
Yes.
Right. So it means that interpretation would be that except for POXO and this rape cases, in other cases, implementing the informant is not essential.
Not necessary.
Someone might do it, it may be desirable, but it may not be, it is not essential. Anyway,
If they desire, they can participate, Lordship.
I also forgot other day, my lord. To
Which
bring
one?
This Boromati Fakir judgment
no, it's okay, no problem.
and Deepak Nayak.
So many case laws.
So, my lord, with greatest respect, my lord, I beseech the court kindly to take up the interlocutory application for
No,
suspension.
I will take it up, no problem. He was sentenced to 10 years, right?
Sentence to 10 years, my lord, under 306. Now,
Let's see, what is the order to be, in the main appeal has come up for, appeal has been admitted.
yes. My lord, just IA, normally we file accompany. So documents we have to rely from the main appeal only.
No issues.
So may I request my lord to have the main appeal?
Yeah. But as per your instruction, it's not yet served.
Not yet, sir. We received that WT message from the OC, Lordship.
So yeah, the OC can still try to serve her a copy, and she can appear in the main case,
Yes.
main appeal, if
Yes.
she wants later on.
Yeah.
Main appeal, okay.
She can appear. Meanwhile, IA, we can proceed,
Yes, Lord.
right? That would be fair. There is the main appeal that I'm just passing the order. 6/11/2000 main appeal, criminal 6/11/2025. Full stop. LCR has been received. TCR has been received. Then I mean, no. The TCR is still awaited. Issue first requisition for the same. The learned prosecution was to take instructions regarding service upon the informant through the concerned police station. And in this regard, the learned additional PP has submitted that
Public prosecutor.
public prosecutor, has submitted that the notice is not yet completed as per wireless communication received in this regard, a copy of which has been placed before the court. The learned counsel for the appellant has placed before a judgment of this court rendered by division bench in the case of
Baramati Pakir versus the state of.
State of Arunachal Pradesh. Drawing attention to para 20 thereof, the learned counsel submits that the division bench has disagreed with the direction given by the by a single bench and held that it is not obligatory on the part of the court to implead the informant as a party or serve the informant with notice before proceeding to hear a criminal appeal filed by the accused against conviction in a case arising out of the police report. However, in the case of Deepak Nayak, it has been held that with regard to cases under the POCSO Act and also with regard to cases pertaining to rape, it would be necessary to implead the informant and issue notice to the informant to give an opportunity of hearing. Stop. The instant case, in the instant appeal, the appellant is challenging his conviction under sections 323, 306, 34 IPC. It is contended by the learned counsel for the appellant that in a appeal of this nature, in terms of the law laid down by division bench of this court in Bormoti Pangi, within brackets Supra, perhaps it would not be essential to issue note to hear the informant, to issue notice to the informant on the part of the appellant or the court. I've given my consideration to the matter. Needless to say that this court, this bench is bound by the order passed by the division bench of this court. Full stop. The direction given by this court in Deepak Nayak is also being followed by this court. Therefore, though it may not be essential, nevertheless, since notice has been issued, the prosecution cell pursued a matter of completion of service upon the informant through the concerned police station in the instant appeal. However, in view of the aforesaid position of law that has emerged, the interlocutory application filed by the convict appellant seeking suspension of sentence and bail can perhaps be proceeded with. So this appeal will be listed.
But not any short date, I have no hesitation.
No, this appeal can come in the natural course also.
Yes, natural course also.
Then depends on the outcome of this actually. Anyway, list the matter after 3 weeks. After 3 weeks. If it is allowed, then this will be disposed of. If not, then you have to file. So this will come after 3 weeks.
Now,
Interlocutory application.
now,
There are 2 ways of going about it, as you know. You are quite, both of you are quite learned, experienced. If we enter into the merits, then it takes a different direction. We have to enter into the merits and see the prima facie possibility of equity.
Yes.
Or we take a different track about, that the appeal may not be heard in the immediate future. Then,
Lordship, I have gone through the inferior judgment, Lordship. There is that clause, 3 clause of 107 is not there, Lordship.
my lord will kindly see this paragraph 101, page 71. That is the end of.
it's a long judgment, huh?
Yes. End of the prosecution case. But see, it is also alleged in the case of prosecution that both the accused persons.
Just wait, which is, so, 101, 101, okay.
Last
This is
time.
also,
It is also alleged in the case of prosecution that both the accused person, namely Heelang Tuglo and Heelang Yadav, had common intention in awaiting the deceased to commit suicide. However, the evidence on record is not sufficient to prove meeting of the mind or common intention of the accused person to await suicide of the. Well, that's, my lord, see, then this, my lord will kindly appreciate mens rea and actus rea. Mens rea would be guilty mind and actus rea would be mean, not physical involvement. You are driving somebody to
Yeah.
commit a suicide. So these, once the learned court below has held himself, that there is no sufficient evidence, my lord. And my lord, this was purely a family discord. First wife, my lord, the second wife. The appellant convict came all the way from Sangram to give him some money. And then he finds his wife drinking beer, wine. And then, my lord, thereafter, the appellant convict, my lord, gets a call from the second wife to attend some guest from there. And thereafter, my lord, kindly see, left, and he came back. He again came back and had a dinner with him. And by the time, my lord, he again started to see again this is again started drinking, my lord. And then, acted this. And then by the time when the call came, my lord, so I was already there at home in the second house, my lord. And then when she came back from there, and then she tried herself, my lord, to commit suicide, my lord. First, try that DW2 is very important, my lord, that daughters. DW2. Kindly see, my lord, just
1 minute.
Yes. And importantly, my lord, the
Just a minute. No, I'm getting some.
Wait, yeah.
It will be relevant to Mr. Yeah, please. No. I'm sorry. Yes.
My lord,
DW2.
yes, my lord, then DW2 page either to be fulfilled. Well, just I help.
You have annexed everything.
PW2, my lord,
PW2.
98. PW2, my 488.
Yellow, I, 113.
113. I'm on the main page.
Main page.
The judgment I will rely. My lord, she's the daughter who witnessed everything in the IE. My lord is having the IE.
Yeah, I'm on the I only. I've taken up the I. I'm on page 96 of the I. Right. So he is Ringu. See, not daughter. PW7. This is 113.
Daughter silang money.
No, just this is a judgment which will be assistance to us. This one. Maybe you have a detached studio for huh? That one is the photo studio, detach it from here. This other take it. Huh? This one. Right. Yes. Page number 1. 1.
My lord, may I just before I take my lord to page 113.
Nilang.
My lord, can we come to flip back to page 64 first? 161. She's the daughter who has witnessed how the mother has committed suicide.
Prime witness.
Yes, it's the prime witness.
This is a police statement. Right.
This corroborates the position. On being examined, she stated that the above mentioned is me. I am second daughter of so and so, late so and so. My papa is a teacher and his job is at Tumla, live at Sangra. He stays there and comes to visit us sometimes. Mommy was waiting for Papa to come since 1 week. On 14/3/17, that is yesterday afternoon, Papa came home and stayed for some time talking with Mummy. Mummy sent me to bring Pepsi. One of our aunts stays there. Our second Mummy's house at Karsisa was also present at home. Papa and Talos Ane, Srimati So and Sayabo were taking Pepsi, and Mummy was taking cane care, of course, my lord, starts from here, all the trouble. We brothers and sisters went to buy sweets, then elders were talking later. When we came, they were not at home. Later in the evening, mommy told Papa will come home so to prepare dinner for Papa. Papa came home in the evening with a pipe. We all sat in the kitchen near the fireplace. After sitting for a while, Papa gave mommy a check. Mommy was angry and tear apart the check. Papa had not given money to mommy last 2 months. SSL teacher, their salary, they gets very late. 2 to 3 months since January to March. Because of this, mommy was angry over Papa. After court argument between the two, mommy drank 1 can beer turbo. Papa was also got angry and in anger threw and broke the plate on which the dinner was to be served for him. But later Papa had a dinner, and after dinner was preparing to sleep at home. Meanwhile, call came to Papa's phone. It was around 9 to 10 p.m. and he had to go to Nichegar, stepmother, Srimati so and so. Mommy told Papa not to go, but despite that, Papa left for Nichegar to our stepmother house. Mommy also ran behind Papa. Later, around 11:30 p.m., Mommy came back along with Masung Dada Sri Hilan Kasu and one but. No? And my lord will mark this in the prosecution trial. This particular man has not been made as a prosecuting witness. I don't know his name. Talo Ane Srimati so and so also came after a while. They all sat and Masung Dada drank 2 can beer, turbo, and all left after sitting for some time with Mummy. Mummy told me to feed my younger brothers and make them sleep. Perhaps Mummy went back again and took Talo Mummy's phone as she don't have her own phone. She was making calls here and there. We all were lying to sleep. Mummy was crying. Suddenly she got up and tried to kill younger brother, my lord, 20 marks. Younger brother with a sword down. At this, I intervened and asked mother not to harm brothers, and I took my younger brother out of the house. After some time, I went to the kitchen room to look for Mummy. I saw that Mummy was preparing to hang herself with dupatta. I tried to stop Mummy and pleaded, Mummy, don't do this. She was furious and shouted at me and hit me with a firewood and asked to leave the room. I threw my younger brothers to our bedroom and slept with them after some time. I again woke up to check up Mummy. I saw that Mummy had hanged herself with a dupatta in the kitchen and she was struggling at her last breath. Seeing this, I rushed to the neighborhood to call for help. When I returned back with our neighboring aunt, Jasur Begum and Sukura Vimila, these 2 persons also has not been made as a prosecution witness in the trial. And others, she still not moving. Aunt told me to inform that I run behind our house to ask neighbor to inform Papa, who was at Nichegar, stepmother's house. After some time, Papa and other arrived home. Now, first, I was not there at all. There was a small family discord, and every family discord will not attract the ingredients provided under Section 107 of the IPC and 306. Now, this fits into the scheme in the form of collaboration, page 113. That's the point. And she has also not been made as the prosecution witness. Instead, she was made as a defense witness.
113.
Now, my lord, kindly see. 113. This was which day? 10th day of March 2025, it was recorded. So, on oath, in examination in chief, what she says. On the date of incident, my mother was consuming alcohol drinks, and my father asked my mother not to consume alcohol drinks, during which they had some argument. After a while, my father has received one phone call from the second wife, my stepmother, from the downside, and my father went away. After a while, my mother started to cry. I tried to console her, and we were preparing to sleep. However, during that time, my mother tried to kill me and my siblings with a dao. I, along with my, dao means machete. It's a machete. I, along with my brothers, managed to flee away from the residence. Thereafter, I have seen from the whole of wall and seen that my mother has committed suicide by hanging herself. Then I have informed our neighbor to call our father and other persons to inform them my mother has committed suicide. Present case is initiated against against my father with false allegations. Consistently, she said, described incident. During the time of suicidal, my mother, I was about 10 years of age. It is not a fact that I was 12 years of age at the time as told by my father. I do not know whether my mother has objected second marriage of my father as I was not born during that time. They were in this suicide had been committed after 18 years of marriage law. That judgment I have. It is not a fact that I was child of 10 years and I could not remember about fact of this case. I have not seen any injury marks on the body of my mother. The Exhibit 2 are the photographs of my deceased mother, but I have not seen the injuries on the body of my mother. The photographs might be showing wrong injuries mark. The eyewitnesses who have seen my father physically assaulting my mother is wrong. But there was no physical assault, nothing.
Keep it inside.
The post-mortem report, which shows that there were about 9 injury marks on the body of my deceased mother, may be correct. It is not a fact that after second marriage, my father used to avoid and neglect my mother. No, this is correct for the reasons that when I came on 14.3, when I came down, I gave her the money. The post-mortem, I cannot say my father, if my mother did not marry for second time, my mother would have been alive. It is not a fact that my father did not use to pay maintenance to my mother, for which check of 6,000 was torn by my mother. I don't know whether my maternal uncle has constructed residence for my mother. I do not know if my father has not given a single penny for construction of residence of my mother as I was small. It is not a fact that second marriage, my father used to stay away from my mother at Krungkume. My stepmother, the accused in the present case, is taking good care of me. Now I am residing with my father and my stepmother. It is not a fact that I am giving false evidence today to save my father and stepmother as they are taking care of me. It is not a fact that I was not an eyewitness in the present case as I have not seen injury marks on the body of them. Because she is the prime witness at the time of committing suicide, my lord. And she has been very categorical, my lord. Now, my lord has seen, after reading 161 and 164 deposition statement of DW2, my lord, from our side, there was nothing as such. There was no provocation, my lord. There was no mens rea at all. Even the actus reus, my lord. Neither the mental nor the physical act can be attributed against the appellant convict, my lord. Because it was due to the consumption of alcohol, and which has been well indicated by the daughter who has witnessed the suicide scene, my lord. So, and therefore, my lord, these concurrently run with paragraph 101 of the impugned conviction order. When you find that there is no sufficient material of abatement of the society, then therefore, my lord, the ingredients that is provided under section 107 of the Indian Penal Code cannot be attracted, my lord. And my lord is aware. Second proposition, my lord can well discernible from these two statements. 161 statement and the deposition by the DW2. Who is supposed to be the prosecution witness number 1? And deliberately, she has not been made as a prosecution witness instead DW, my lord.
Instead DW.
Instead DW. This is not supposed to be. But therefore, my lord, Prima facie, my lord, I have this 2024 judgment, my lord. And these all judgments are already relied on. Just kindly- Jaideep Singh Parvaris, my lord, that's 20 latest judgment only, my lord. My lord, eight children, my lord. 8 children. And he is the only breadwinner, my lord. And because of this wrong conviction, my lord, the children are suffering, my lord. My lord, these are settled law, paragraph 10, my lord, it starts. My lord, my lord, kindly come to paragraph 70, the straight of this judgment.
17.
17. 16, my lord, is the 306, my lord, ingredients is better to
Yes.
read from 16, para 16, my lord.
17.
16 onwards, 16 and 17 we read and then I'll come to the conclusion. Section 306 of the Indian para 16. my lord. Sorry, my lord.
No,
Section 306 of the Indian Penal Code provides for punishment for the offense of abatement of society. It has to be read with Section 107 of the Indian Penal Code, which defines the act of abatement. The provisions read as follows. 306 abatement of society. If any person commits suicide, whoever abates the commission of suicide. My lord, kindly mark these words. Abates the commission of the suicide. Now, my lord has seen only a small family discord was there. I have physically not done anything to abate the suicide, my lord. Shall be punished with imprisonment of either description for a term which may extend to 10 years and also liable to be fined. 107, my lord. Abatement of a thing, a person abates doing of a thing who first instigate. My lord, here, my lord has seen there is no instigation at all in my case. To do things, or secondly, engages with one or more other person or persons in any conspiracy for doing of that thing. If an act or illegal omission takes place in pursuance of that conspiracy and in order to doing thing of that things. This has been answered by the learned district judge himself in paragraph 101. Thirdly, intentionally aids by any act or illegal omission doing of that thing. The explanation, my lord, is very important to read. A person who by willful misrepresentations, here is not case of misrepresentations or by willful concealment, there was no concealment at all, of a material fact which he is bound to disclose, voluntarily causes or procures or attempt to cause or procure a thing to be done, he is said to instigate the doing of that thing. Here, my lord, absolutely this explanation is not applicable in my case, my lord. 2. Then 3017, my lord, come, para 17, that explanation too, I will not read it because there was nothing prior also. Para 17, section 306 of the Indian Penal Code penalizes those who abet the act of suicide by another. For a person to be charged under this section, the prosecution must establish that the accused attributed to the act of suicide by the deceased. My lord, kindly see the word attributed. I have done nothing in this. This involvement must satisfy one of the 3 conditions outlined in section 107 of the IPC. The condition includes the accused instigated or encouraged the individual to commit suicide, conspiring with others to ensure that the act was carried out or engaging in conduct, or neglecting to act, that directly led to the person taking his/her own life. My lord, I'm pausing for a moment, giving the explanations. Now, in 161 statement, the prime witness of the suicide as a daughter, 10 years old. And secondly, my lord, she stands as a DW2 instead of prosecution witness number 1 or 2, my lord. She categorically says My father has never instigated, even after the second marriage, my lord. My father takes care of us. My father takes care of my mother. And my lord, the statement itself, kindly see that on 14/3, when I came down from Sangram, from my place of posting after getting the salary, I paid 6,000 rupees to her in check, and that check was torn apart by the deceased. And this is conduct by himself, my lord, kindly see, was consuming alcohol. Excessive. Had it been a 1 or 2 cane, my lord, that could have been different. But it is, my lord, there is a word I think I have used other day. I think 406 or my lord, this IPC, this measure. Probably, my lord, since I was not there, this must have been the act of God. Now the act of God, my lord, the word this measure might contain two things. One, the positive spirit, another is the negative spirit. Probably at that relevant point of time, she was guided by the negative spirit. And so therefore, she has committed suicide by herself. And from the material available on records, my lord will not find a single act of mine instigating her to commit suicide. Where is that this measure? Where? You have the CRPC. But I am trying to find a particular word this measure in the this right. Purna wala mein. 406 or no, 406 IPC it should be. Well, just say. There is a word anyway, my lord, that I'll find out because I remember long back doing this. Well, therefore, the distinguish that I'm making is in the life of a human cycle, my lord, there are always two energies. One is negative, another is positive. So thereby, my lord, a person has been brought to the dock of a candid strife of devil and deep blue sea for committing no crime and then has wrongly been convicted. Therefore, my lord, my respectful submission would be, I would be relying, my lord, paragraph 16 to 19, my lord, 20, 22, and 26, wherein in the same case, my lord, I find out.
This judgment.
Yes, in the same judgment, paragraph 18, my lord, kindly see. That is what I was trying to distinguish, my lord, for a moment, my lord. For a conviction under section 306 of Indian Penal Code, it is a well-established legal principle that the presence of clear mens rea, my lord, the intention to evade the act is essential. Mere harassment by itself is not sufficient to find an accused guilty of evading the suicide. My lord, kindly see, as I was referring to a while ago, when the Honorable Apex Court, in its wisdom, is very clear about the definition and the meaning of the mens rea. The mens rea, my lord, first is the guilty mind, second is the actus rea, my lord. That is the guilty act. Now, my lord has seen, even from the content of the FIR, even from the church seat, my lord will not find any act that I have evaded the suicide, my lord. Nothing as such. My lord will never find, my lord. His own life, the element of mens rea cannot simply be present or inferred. It must be evident and explicitly discernible. Now, my lord, I'm again reiterating for the purpose of this application is that it says is presumed or inferred. When there is prima facie lack of evidence, how the conviction could have been held. And my lord, the learned district judge, I'm reiterating again, my lord, 101, paragraph 101. So therefore, my lord, this is a fit case where the appellant convict can be released on bail by imposing any conditions, my lord. My lord, kindly para 19 also is very important to understand, my lord. I'll not read this, para 19, instigate, my lord. I'm on the word instigate on para 19 of this judgment, my lord. Well, see, my lord, only in the Ramesh Kumar versus State of Chhattisgarh, my lord, the word instigate as under, my lord.
He didn't goad, urge, forward, provoke, incite,
Nothing,
encourage. These are the
nothing.
words.
Nothing is there, my lord. Then kindly see, my lord, 20, kindly come, my lord, this is important, my lord. The essential ingredients, 20, the essential ingredients are fulfilled in order to bring a case under section 306 IPC are the abatement, my lord, one. Number two is the intention of the accused to aid or instigate. This is absolutely absent in this case, or await the deceased to commit suicide. Nothing, my lord, absolutely, my lord. Now, para 21. Thus, to bring a case under these provisions, it is imperative that the accused intended by their act to instigate the deceased to commit suicide. Thus, in the case of death of a wife, the court must meticulously examine the facts and circumstances of the case as well as assess the evidence presented. It is necessary to determine whether the cruelty or harassment inflicted on victim left them no other option but to end their life. My lord, I am posing and giving my interpretations here. My lord has seen even in the FIR, my lord. FIR is a hearsay, my lord. It's a cousin brother who has come and filed the report. And then the statement of the daughter, nothing. No, yes, ocular evidence, you are correct. So, my lord, therefore, this is a mere allegations. And it is like a crystal clear. The water that flows in from the Ganges.
No, it is a very challenging section, abatement to suicide. See, the thing is that what is happening in 306 is that many judgments have come.
Yes, no.
That a person A, he creates certain circumstances.
Yes.
And the victim B commits suicide.
Yes.
And those circumstances might have a relation with the suicide of the victim B.
It's hard to.
Yes.
make sure.
But they may still fall short of the definition of abatement.
Correct.
So in that sense,
Yes.
probably we need a new penal provision. This is my opinion for a long time. Long time, like 65 has been, what is that section brought in BNS? That, because it is still there by legal fiction, that if the, this relationship was committed with a promise of marriage, which was false from the beginning, then that consent is no consent.
Yes.
So by a legal fiction, that was taken to be rape.
Deepak Gulati versus.
Deepak Gulati. Uday,
Then,
Deepak Gulati.
thereafter, that Shanmugam judgment in 2021.
So new section, now we will not
Yes,
digress,
brought
but that new section has been now brought in,
69 of the.
that particular relationship with false deceit.
Yes.
So here also there is a scope, that's for the lawmakers to decide. Because I have seen that there are circumstances. The person is responsible for those circumstances, definitely.
Yes.
And there is also a suicide, but abatement is something, it is falling short of abatement. So if you want to penalize that person for creating circumstances leading to the suicide of the person, then abatement is not an answer. Because abatement means something different.
Yes, sir.
And this, this expression which Honorable Supreme Court has said, this will have application that that creating circumstances where the victim has absolutely no option but to end the life, right? So that means, so we can interpret it in this way. There are two ways of looking at it, actually, in my opinion. One way of looking at it is that this would mean that the only way sees the victim is trapped in such a situation that the only way she can escape that situation is by dying.
Correct.
And how will she die? By killing herself. Otherwise, if I look at it another way, this is beyond law, this thing. Nothing in this world justifies taking your own life. Nothing, if you look at it that way. So if it's a bad relationship, walk out of it. Leave that person.
Exactly.
Something like that. But life is too precious.
Yes.
But it happens. Many people commit suicide. But this is my experience of 306, that it's coming. It will be very interesting to have a look at the statistics about the conviction rate of 306. We cannot prejudge the appeal. Of course, there are convictions, there are their convictions, but again, the prosecution is meeting the challenge of, you know, that meeting the definition of abatement, the ingredients of abatement, which is conspiracy, instigation, aid. Aid.
Physical aid.
Aid.
Yes.
Yes, someone commits suicide and I,
People also- people are
and
not
and
there.
that person brings the rope, suppose. Nothing, it's a phenomena like suicide is a, you know, it's it's a big tragedy. That will be a very, you know, full silly example of a aid, but a true example. Instigation is again, you know, something like that. Prod, you know, push, encourage,
Yes.
conspiracy.
So therefore, my lord, this.
So
the
this much, you
purpose-
know, we cannot take a, you know, review, since we are not hearing the appeal.
Yes, sir.
We cannot express anything on the, you know, the possibility
The merit.
of this side or that side, and that will be unfair. So, but as far as suspension of sentence is concerned, yes, I mean, that's what I
8 children, my lord. They have to be taken out from the hospital.
and 8 children, and here, you know, it's what a tragedy. There are two appellants, one appellant.
One
No,
appellant. And my lord, the second wife was also convicted, but was
I see.
discharged on 360. So on that position also, my lord, the benefit should also be given to him.
The suspension of sentence is sought by only
By.
Hilang Tugru,
Yes.
who was the husband.
Who was the husband? No, my lord, kindly state the suspect.
This judgment, there was probably you are aware also, this also we have to, you know, since we are deliberating so much. This was,
26,
this was come on 8/5/2025, this judgment.
Latest judgment.
Latest judgment, 8/5/25.
So
This
this
is
is the final one. Otherwise, my lord, law started from 2005 on abatement of suicide.
okay.
Well,
Yes,
this paragraph 26 also.
The statement of eyewitness is consistent. There is consistent statement, lordship.
Here the appeal and, okay.
And 107, ingredient 107 is not there, lordship.
The abatement is truly, you know, in this kind of things, something like suicide, it's truly challenging. But then, yes, there are many cases where the prosecution is able to successfully prove also, but there are many where it falls short also. Okay, have your seat. I have dictated this. Heard. Yeah, can I dictate? Shibu. I can dictate? No problem. Learned counsel for the applicant / convict appellant. 22/10/2025, the second paragraph as it is here. Good stop. Though notice was issued upon the respondent number 2/informant, but the prosecution, after taking instructions, submit that notice is not yet served. In this regard, the learned counsel for the applicant has placed division bench judgment of this court in the case of Bormoti, and referred to paragraph 20. Full stop. The said paragraph 20 may be reproduced herein below. Full stop. In the case of Deepak Naik, ... Deepak Naik was a single bench or double bench? Division bench. Another division bench of this court has held that in cases pertaining to POCSO and rape, the informant / victim has to be noticed and given an opportunity of hearing. Upon perusing both the judgments, both the case laws, it is clear that in a criminal appeal of this nature, Perhaps it would not be essential to implead and notice the informant. However, in the main criminal appeal, the prosecution has been directed to take further instructions regarding the regarding service upon the informant. As the informant has been impleaded. However, in view of the case law referred to above, I am of the considered view that perhaps the interlocutory application pertaining to interlocutory application pertaining to suspension of sentence can be proceeded with. As already stated above, the applicant was convicted and sentenced by judgment and order dated 16/9/25 and 17/9/2025 respective. Full stop. He was convicted and sentenced under 323/306/34 IPC. What was the sentence? Sentence time লিখিব লাগিব দেই।
10 years.
For conviction under 323, he was sentenced to undergo imprisonment for 1 year. ID. What was the fine? Not been written properly. No? We go to the cost title of the judgment. As per order. Okay. 1 year for it to 323 for the conviction under 306 IPC. The applicant was sentenced to RI for 10 years and fine of rupees 10,000. ID in default, SI for 2 months. The sentences are concurrent. He is undergoing. When was he taken into custody? From the date of the judgment? Not very recently. It is submitted by the learned counsel for the applicant that the applicant is presently serving out the sentence from the date of sentencing. The learned counsel, Mr. Tara, has taken the court through some portions of the depositions of the witnesses adduced at the trial, including that of one daughter of the accused and the victim, who were husband and wife. Full stop. The learned counsel has also referred to a decision of the Honorable Supreme Court in the case of Jaideep Singh, Praveen Singh Chadha versus State of Gujarat, 2024 in SC 960. Referring to various paragraphs in the judgment, the learned counsel submits that in the said judgment, the Honorable Apex Court has discussed the ingredients of what would constitute an abatement of suicide within the meaning of Section 306 IPC, and contends that from the evidence in the instant case, such ingredients are not made out, and that therefore the conviction of the accused, the applicant under 306 IPC is a wrong conviction. On the other hand, the learned additional PP.
Public prosecutor.
Sorry, I'm so sorry. Next time I say it, you should impose cost on me. Yeah, you can also. Why not? On the other hand, the learned public prosecutor supports the impugned judgment and order and contains that there is no infirmity in the conviction and sentence, and further submits that there is no merit in the appeal. Full stop. I have perused the relevant materials and given my consideration to the matter. At this stage, I do not deem it necessary to delve deep into the merits of the impugned judgment, which shall be gone into at the time of the appeal hearing. In Jaideep Singh Praveen Singh within bracket Supra, it has been held in para 20 that incessant ingredients of section 306. Para 2021. Before proceeding further, I also refer to a recent judgment/order of the Honorable Apex Court rendered in the suo motu writ petition criminal 4 of 2021 in re policy strategy for grant of bail. Full stop. Para 13 thereof may be reproduced herein below. Rasi. Thus, in this judgment, the Honorable Apex Court passed recently, the Honorable Apex Court referring to the cases of it within Supra has held that when there is a fixed period of sentence, normally the power of sentence, suspension sentence should be exercised liberally unless there are exceptional circumstances brought on report. Full stop. I have given my due consideration to the said judgment and the narration of the Honorable Supreme Court in para 13 thereof. Full stop. Unlike the principal seat, here we cannot really say that it will take, the time frame would be comparatively less, but still without statistics, you cannot say.
Yes.
You have to know one very important piece of factual information that you may need is that, like in a doctor queue, that what is the queue number of this appeal in the list? Then only you have, that's the thing. Then only you have. Keeping in mind the principles laid down by the Honorable Apex Court in the decision mentioned above, and also the possibility that perhaps the appeal may not come up for final hearing in the immediate future. I am of the considered view that despite the nature of the sentence, that is 10 years, all right, the same can be suspended, granting bail to the accused, the applicant. However, suitable conditions have to be imposed to address legitimate concerns like welfare and safety of witnesses and the victim and the victim side. Accordingly, in exercise of powers, I think now it will not be 389, this will be the new section now,
New section.
you know. BNSS, I have somehow managed, but the BNS, I'm having a tough time still.
Yes.
You know. Recently, there was an interesting judgment of Allahabad High Court. I think Allahabad High Court, that all petitions along with BNS, you have to mention the whole sections also.
430.
430.
430. I have mentioned in the.
430 of the BNSS. The execution of the order of sentence dated 17/9, right? 17/9/2025, passed by the learned Session Judge UPIA in Sessions Case Number 14 of 2019 shall remain suspended till disposal of the appeal. Full stop. In the context of the same, in the context of the above, it is further directed that the convict appellant so and so allowed to go on bail. Let us give the bail amount a little high. 50,000 more or more.
50,000 is more.
50,000. Usually I always have a habit of giving lesser, but now, you know, certain circumstances, because
Yes.
monetary value is also increased. 50, because in any case, he doesn't have to give money. 50,000 with one surety of the like amount to the satisfaction of the learned trial court. And subject to the following conditions. Amar, we have some conditions that he shall not abscond. Number 2, he is a resident of UPIA. Can he, because one of the conditions I prefer to impose is that every 2 or 3 months, that can be a matter of detail, he should record his presence before the trial court. This is necessary, you know, once he is around, because only there are 2 concerns, that absconding and harming someone. Investigation, all these concerns which are there in the stage of investigation are not there. But this kind of bill.
Duty is at Colore Ekmala.
Absconding lordship, he is a government employee.
Government employee, you know, that may not.
He is a government employee.
Government employee.
Trained graduate teacher.
He shall be, instead of absconding, you're right, he shall be available to receive the appellate judgment. Number 2.
Correct.
Every 3 months, he can record his presence before the trial court. That should be possible, I think.
But why?
Is it very far? Because that is, I think, one of the conditions. Because, you know, what is this condition? Okay, government servant, but just imagine
But,
someone being sentenced to 10 years. It's not a
But,
joke. So the idea of, I'll just come to you. The idea of such a condition is that to ensure that the appellant is around, he's around.
My lord, may I just request, Lord, instead of magistrate, can it be Karsansa police station where my house is also there? Narlagan, Bandardua police station.
Because the how far is UPIA from his place?
UPI is 30 kilometers.
Kilometers. He's getting a big relief here.
15 kilometers.
10 years
But 15
suspension.
15 kilometers.
Let him take that trouble, and
Yes.
he shall record this presence before the learned trial court, that is Sessions Judge UPIA, once in every 3 months. So the learned court below shall be at liberty to fix the date for such appearance, and also be at liberty to modify the time frame.
Correct.
I'm giving full flexibility.
Yes.
Suppose the trial court is convinced that, okay, once in 4 months, no problem, flexibility, right? He shall not harm or harass any prosecution witnesses who have adduced evidence during the trial. He shall not harm or harass or threaten the informant, victim, they're same family, but the informant and victim and their family members. In case of violation of the bail conditions, the bail would be liable to be cancelled. In case of violation of the bail conditions, the prosecution of the informant side shall be at liberty to move an appropriate application for cancellation of the bail, right? This is necessary. The interlocutory application stands allowed and disposed of on aforesaid terms.
Deeply grateful.
Because that sword is always over the head, right?
Yes.
10 years.
Yes.
You know, that liberty is, you know, the person mentally will never feel free because that thing is there. He's under a sentence. It's no longer an investigation. It's no longer a distance. So,
My lord, I call it as a Damocles sword.
Damocles sword, right? Exactly. Exactly. Damocles sword only. So, yes, concerns can be there. Another thing, sometimes actually we should impose. Sometimes, in some cases I have imposed some, maybe we should not, that the convict appellant shall not in any manner harm himself. Yes, he may, someone may, isn't it?
Yeah.
That is also a condition. People get scared, all kinds of things can happen.
Yes, Lordship.
He may end his life. That if this is gone in my favor, I appeal fails, I go 10 years. So this is also thing. How do you enforce this condition? That's another matter. But sometimes I impose, sometimes I don't. Let's see. At the time of correcting, I may disposed of. And this is disposed of. Appeal is after 3 weeks.
After, obviously.
Item number 16. Take a break. Take a short break. Take a short break, huh? We'll call him. Yes. Adav Sonowal. Yes. You could put this here. I this in the file now.
My lord,
Yes. What is the matter?
one IA with criminal
So,
investigation with IA. IA is for interim ban.
TCR was not received. Has it been received in the meantime? Service report not yet received.
My lord, I think for letter 6 day after tomorrow at my near task is not.
Okay. We'll not take up today?
Yes.
Another day.
Day after tomorrow.
Okay, no problem. No problem. But I'm just checking whether, because we can issue the reminder. Original. No. Oh, it's against conviction, right?
Yes.
Appeal 326. Peruse the order dated 23/9/2025. The revision petitioner is challenging the concurrent findings of guilt by the learned courts below. Convicting and sentencing under section 326 IPC. Full stop. As per office note dated 6/11/2025, the original TCR has been received. Mahadevpur, PS case number 5 of 2012 has been received. Full stop. But service report, anyone from the prosecution, sir? Yeah, this also is similar actually. Revision, it is not, is it necessary? Implead the respondent revision. The same principle will apply, I think. Service report is awaited. He has impleaded.
Yes, Lordship.
No harm, actually.
Yes.
I was telling you that there's a very recent judgment. You can search. I think last 3 months it has come where the Honorable Apex Court has said that the victim should get an opportunity to participate at every stage of the criminal proceeding, from initial bail to all the way to. In that case, this will undergo further change. But as of now, we have this that except POCSO and we are not. It's not essential. But anyway, service report is awaited. Let's wait.
Yes.
Because any case is seeking adjournment. TCR has been received. You day after tomorrow or after a week or sometime?
Day after tomorrow.
Day after tomorrow. Because service report is awaited.
Even if it's listed on day after tomorrow, if not come, then
Service report as per office note dated 7/11/25, service report upon respond number 2, not yet received. List the matter on 12. Day after tomorrow is 12.
Yes.
Item number 17.
Your Lordship, on last occasion, I was instructed to take fresh steps, Your Lordship, and accordingly, I have taken steps.
Yep. Good. Uh, 31/7, right? PCR as well as service report is not requested. PCR. It took in July only, no? So it should have come actually by now. TCR is not received.
No, Lordship. Lordship, service upon respondent number, Lordship,
2. 2 and 3.
Yes, Lordship. It's not been completed yet, Lordship. So it may be directed to OCPS, Lordship, to serve the notice through OCPS, so that it will be
No, he has already taken steps. He shall take it again. No, what?
I think it's a new service, maybe issued, Lordship, because Lordship, they have already taken.
They have
more than
taken,
2,
but
3
that's
times,
her-
Lordship.
30th July only. Would you like to take fresh steps to the concerned police station?
Okay, Your
If
Lordship.
it's not cumbersome. Yes, hmm? If it gets, remains stuck, then better to take.
Yes, Your Lordship, I will.
Peruse the order dated. It has not come up for a long time. It's not come up for a long time. Peruse, last order dated 31/7/25. Stop. As per office note dated 7/11, TCR not yet received, nor service report with regard to respond number 2 and 3. The issue fresh requisition for the TCR. Further, the petitioner side shall take fresh steps upon respond number 2 and 3 through and steps shall be sent to the concerned police station.
Yes, Lordship.
How is it done? Through the registry,
Lordship, yes, Lordship, to register.
and they go to the
Yes, Lordship,
concerned
concern
police
or CPS, Lordship.
station. That's better. Okay, list after 3 weeks.
3 weeks, Lordship. Yes.
3 weeks.
Lordship,
3 or 4 weeks.
scan copy of the TCR maybe, scan copy, Lordship.
Yeah,
Interim granted. Or interim not granted.
issue fresh requisition for the scan TCR.
Yes, Lordship.
Interim is you're seeking interim.
Yes, Your Lordship, I'm seeking interim in IA, Your Lordship.
Why is there? Should we wait for their appearance for the stay, or there is some urgency?
Lordship, we have no TCR, Lordship. That's why I have no idea in what
Yes,
state
yes.
it is going on. Okay.
Let's wait for the stay order can be passed here also. In the main case also, stay order can be passed. Because if the stay is granted, then this will dispose it off. You know?
Lordship, stay, sorry, a charge sheet already been submitted, Lordship.
Proceedings is going
Yeah,
on.
proceeding
Your-
going on, Lordship.
So Your Lordship, in this case, I am alleged of receiving an amount of rupees 15,50,000, Your Lordship, out of which I have already paid all the amount, Your Lordship.
Then we have to little go into the merits.
Your Lordship, Annexure 1, page number 16 is the message received from the complainant, Your Lordship.
Of the IA,
No, no, Your Lordship, main case, Your Lordship.
main,
Your Lordship, in IA also it is annexed, Your Lordship.
just a minute. Okay, which order you want me to see? Okay. The agreement,
Annexure 1, Your Lordship,
Annexure 1.
message from the complainant, Your Lordship.
Okay.
He has received the amount, Your Lordship. Let me-
Okay, it can be stated. Mudit Dixit.
Yes, Your Lordship. I'm Mudit Dixit, Your Lordship.
Otherwise, stay may be granted. I have no issue, Lordship. Whether
No, that's okay. It will be justified. Wangsu has received. He has acknowledged.
Yes, Your Lordship.
Ma'am. Then, yeah, that's it. Law application, criminal 39. What we can do is, this, from page 9, check the first paragraph. Same. Friends. This interlocutory application has been filed by the petitioner with the prayer that further proceedings of GR number 74 of 2019 pending before learned JMFC Khonsa may be stayed. It's quite an old case, no?
Yes, Your Lordship.
This needs to be decided quickly, whatever it is. All right, if it's settled, then so. the main proceeding has been preferred by the applicant under 528 BNSS, seeking quashing of this criminal proceeding, which arose out of Deomali PS case number 10/2019 under section 120 420 34 IPC. Where can I find the FIR? FIR is here
Yes, Your Lordship.
in the IA. It is there.
In main case, Your Lordship, it is annexure 2, Your Lordship.
Page 18, Lordship, I think type copy.
Mhm.
Page 18, Lordship,
18,
1818.
18. Total amount was 22 lakhs something. 22 lakhs
Your
63.
Lordship, I have received only 15 lakh 50,000 as per his complaint also. As per complainant also, Your Lordship. Rest of the amount is received by co-accused, Your Lordship.
Nice.
That is respondent number 3, Your Lordship. Neeraj Singh.
The gist of the allegations in the FIR dated 22/9/2019 is that the accused persons making fraudulent and false representations made the complainants give money amounting to more than 20 lakhs, 22 lakhs, and thereafter started becoming evasive, as a result of which the complainants allege that they have been cheated. They have been cheated with conspiracy. Full stop. It is submitted by the learned counsel for the petitioner / applicant that he had received an amount of rupees 15 lakhs, perhaps received an amount of rupees 15 lakhs from the complainant, and that the same has also been returned to the complainant. And in support of the same, draws my attention to WhatsApp message, a copy of which has been annexed to the petition with the IA. Date is not there, no, March 25 March. The date, the message indicates a date of 25th March, which here it's not that, and indicates a communication between Mudit Dixit and Matpho Wangsu, and that the said Sri Wangsu acknowledged receipt of rupees 15 lakh 10,000. It is submitted by the applicant that without the stay, the proceedings will continue, causing serious prejudice to him, and might also make the criminal petition infructuous. Also heard the learned additional PP. So what submission should I record from your side?
Lordship, here, Lordship, today, Lordship, the teacher has not been received. Lordship is disposing the matter, Lordship.
IA.
IA, Lordship, yes, Lordship. Today, Lordship, if IA, Lordship, they have, Lordship, then Lordship in the stay, Lordship may be granted till the next date, Lordship.
Then it will not remain, then it will be remain pending. I will remain pending.
Yes, Lordship, because Lordship,
it's okay.
this year may be called for, Lordship.
Learned additional PP submits that as the TCR has not yet been received and may be perused, but fairly submits that perhaps till the next date of listing stay can be, the prosecution does not object to grant of stay. Fine, fair enough. We have to be always careful about, the councils, standing councils, public prosecutors recording your submissions.
Yes, Lordship.
And they will not record something which you have not said or,
Oh,
right? No,
Lordship.
well, it's my duty
Yes.
or which might put you in difficulty or something.
Lordship, you have.
This is okay, this is
Yes,
fair.
no, notice maybe issue.
Yeah, no
Lordship.
problem.
Yes,
This is
Lordship.
okay. I have recorded. Very fair submission, very
Yes,
fair. All of you are very fair.
Otherwise,
So,
Lordship, because 2019 matter,
Yes,
it is only this
yes, yes,
pending. Lordship.
absolutely fair. There, but in the given circumstances, the further proceedings of GR number so and so. Yeah, this for us. GR number. We have just mentioned, no, GR number. GR number 74 of 2019, pending in the court of learned GMFC, Bonsa, Irab district, AP, shall remain state till, for the moment, till the next date
In
of
the
listing.
next date, Lordship.
Next date of listing, right?
Sure.
Let it be till the next date of listing. In that case, the IA will remain pending.
Lordship.
IA will not be disposed.
Yes, Lordship. Only Lordship, interim is granted, Lordship.
Mhm.
Yes, Lordship.
Interim is granted, but till the next date of
Till the
posting.
next date.
If I grant stay till the disposal of the criminal petition, then it will decide, I will dispose of, like that suspension of sentence.
Lordship, they will.
Suspension of sentence is till the disposal of the appeal, so it's disposed of.
No, Lordship, till
Ah,
the next date
yes.
only.
So it
because
will
by
remain
the next
pending.
time, yes, Lordship.
It will
the
come
PCR
along with
report
the
all-
appeal.
Yes,
It
Lordship.
will also serve its purpose.
Yes, Lordship.
That's okay. Leave the matter. Did we give a date in this main petition?
Yes, yes.
Fresh steps, no? This after 4 weeks, we said, no?
Yes, Lordship.
After
Because
4.
step.
Now, this one I give 4 weeks, 3 weeks. Make it 4 weeks. No, sorry, it's a whole case, right?
Yes,
3 weeks, 3 weeks. And I also list after 3 weeks along with criminal petition 74 of 20. That will take much of
Apply.
item number 18. I'm very happy with your team, standing councils, public, very happy. It was good,
Much
doing
like
good
that.
job. You have a bright future. Keep up the good work. Fair submissions, really enhance the credibility of the system, really, institution.
May press lordship.
Okay, now we are
About-
17.
Lordship.
Oh, this is we have done. This is what matter?
Lordship,
I
I is for condonation of delay, Lordship.
delay.
But yes, Lordship, step is not completed, Lordship.
Steps are not complete.
Yes, Lordship.
It's a jail appeal.
Yes, Lordship.
We condone that.
Lordship, this,
Like the earlier one.
this legal aid council, Lordship, on the last occasion also, he didn't turn up, Lordship.
Some miscommunication. Otherwise, we can appoint another one also.
Yes,
But
sir.
this is appointed by the court or
Yeah,
the
by the court,
legal
Lordship.
service committee?
By the court, Lordship.
By the court?
Yes,
Then-
there is a panel list.
Yes, yes. No. Principal seat I was appointing like that.
Yeah.
But Registrar cum Secretary this order that High Court Legal Service Committee shall appoint a legal aid counsel from the panel.
Yes.
I will use it. That's good. Yes, yes. Three zero four, right? JLP. JLP. As per order dated 18/6/2025, legal aid counsel was directed to be appointed. And we have to see office note. perused office note. It appears that no legal aid counsel has been appointed. Therefore, we'll appoint.
Yes.
This is the and you are familiar with this list, right? High Court legal service it has to be. We can also appoint it. Well, there I was appointing. The court was appointing. So you can suggest since I'm new. Yeah, advocate. You can suggest. Kani
Nada.
comes.
Yes.
regular.
Yes.
Learned counsel Kani Nada Ali is hereby appointed as amicus curiae to represent the convict appellant who has preferred this appeal from jail. Appeal memo will be prepared and filed. It is already.
Yes. Yes. But the TCR is not called for lordship.
Yes, yes. The appeal is admitted for hearing.
Yes.
The TCR of what is PSG? PSG? PSD. Pasighat, sir. This, PSD sessions case number 13 of 22. Within bracket arising out of Kaing PS case number 1 of 22 shall be called from the court of the learned session judge.
Pasighat lordship.
Session judge, learned special judge NDPS. No, NDPS.
Lordship is 304 lordship.
Yes, yes. How come? Oh, achha, he's also NDPS charge. Session judge is Siang district, Pasighat. Stop. He's also NDPS. So he's written. Actually, no need to write here. Actually, yes. No. That's all.
Yes.
This is the matter after 4 weeks. 4 weeks.
Diploma.
IA is also,
IA is for condonation of delay lordship.
Condonation delay. No, I made a mistake then, I admitted the appeal, but modified. What is the quantum of delay?
Quantum is lordship.
We can condone it since it's a jail appeal.
Yes, lordship. This may be delay may be condoned.
The convict, then otherwise we'll have to modify this order because I admitted.
Oh, yeah, yes, lordship.
In the context of the convict appellant preferring an appeal from jail against his conviction and sentence under 304 IPC. This interlocutory application pertains to the delay in preferring the said appeal. The quantum of delay is mentioned somewhere.
Yes, 2 years, 5 months, lordship.
2 years, 5 months.
Yes, lordship.
Full stop. Sri so-and-so learned counsel appointed as amicus. TCR has already been called for in the criminal appeal. Full stop. Third, learned public prosecutor, who fairly submits that perhaps the delay can be condoned, considering the fact that this is an appeal from jail against conviction and sentence. Therefore, and as statutory first appeal in criminal law is a very vital right. It should not be denied. The delay of so and so days to
2 years, 5 months, lordship.
2 years, 5 months in preferring this appeal is hereby condoned. Stop. The instant IA stands disposed of,
Yes.
allowed and disposed of. Okay. I'll take a 5-minute break.
Yes.
Nice. 19.
At number 19.
Item number 19, 20, 21, arising of same affair, lordship.
Criminal petition.
We didn't receive TCR, lordship. There is no TCR, lordship.
He's taking quashing up. Let me see.
Yes.
There's a long order. Let me see this. I read it. 8 out of 12 witnesses already examined.
Yes, Lordship.
So if there is nothing against him in the depositions,
Yes, Lordship.
then it will result in acquittal. So this is,
Even, yes, Lordship, even if.
this is also a peculiar exercise of jurisdiction, that trial is also at the fag end, not process, but that anyway, that's, he has a right to prefer this jurisdiction also. So this is a very nice elaborate order written by Mr. Jahan. So, TCR, though, it will be necessary.
Yes.
Right?
Yes.
Depositions will be necessary. We call for the TCR. We await for the TCR. And the other two petitions might be two other accused, right?
Yes, Lordship.
So same order.
Rising of the same FIR, Lordship.
Here is the order dated 36/2025. The Ingo and the learned PP report is a slide cut. And then after that, you write Perust order dated 36/2025. As also the office, and also the office note dated 7/11/25. Neither the TCR nor the service report in respect of 1 and 2 are state parties. 1 and 2, respondent 1 and 2. 2 is served or what?
Two is the Lordship, the informant. Informant, Lordship.
And he has also,
The SI.
who has been served? Or is the police?
Yeah,
He's a SI police.
yes, SI. Police.
Then you can represent him.
Yes, I will.
Nor the service report upon respond number 3 to 7 has been received back. So we await issue phrase requisition for the scan TCR
Yes, Lordship.
and
Reminder maybe,
reminder.
yes.
And this notice 3 to 7. When was the steps taken? It was,
The second on, 2nd July.
would you like to take fresh steps or should we wait? It's a long time.
Let us wait for the ones. Otherwise,
It's, in the meantime, just try for the other people finish. Anyway, I wait. List the matter after 2 weeks, 3 weeks, 2 weeks.
what's the interim? Interim.
Yes. The interim order, past fight order dated, that same order. 36/2025 stands extended till the next date of listing.
Definitely.
Item number 22.
It's to 19, 20, 21.
May I please, my lord? My lord, by way of this petition, I'm praying for quashing of the proceeding, which is pending before the Chief Judicial Magistrate, Bomdila.
Mhm.
My lord, the foundation, in this case, my lord, the foundation upon which the whole case is structured is fundamentally flawed in fact as well as in law. In this case, my lord, the FIR was lodged on 26 February 2014, which is 11 years back, with the allegation that an unknown person has fired 3 rounds of firearm and damaged the truck without any provocation and left the spot. And basing on that, my lord, criminal law machinery was set into motion.
Just a minute. What is, let me see, let's clear this order. Scan record has come. It has come. The GR case is going on.
Yes, my lord.
It's going
So
on.
if I'm only praying for the stay of the proceedings, since the matter is pending since last.
You wanted to show me
My-
something? Please.
My lord, may kindly have page number 24, is the FIR.
Yeah, little stuffing,
If I may read,
24.
24.
Yeah.
With due respect, I have the honor to inform you that on 25th February 2014, I along with my handyman Sri Govind Chetri were coming from Tawang towards Tezpur by truck bearing number so and so. On the way near Dumdum Nala at around 15:30 hours, while my vehicle was going up at slope, one vehicle coming behind me was seeking pass, but due to narrow road condition, I could not give immediate pass, and after covering few distance, I gave way to the vehicle and later the vehicle overtook and stopped my vehicle, and one unknown person sitting in front side seat adjacent to the driver took out one pistol and fired 3 rounds on my truck without any provocation from my side and without any valid reason and left the spot. registration number so and so, and the word press in red letter on front windshield was also seen. When that vehicle overtook my truck, therefore I is requested to take necessary action against the culprit. Basing on this, my lord, investigation was carried out, and eventually, my lord, it was culminated into charge.
West coming, is no?
My lord.
By 6 of 14.
My lord, if my lord may kindly have for a time being page number 26. That is the charge sheet.
Charge.
Charge sheet was filed under section 341, 336, 427, and 25 and 27 of the Arms Act. My lord.
Can we read this?
My lord, I'm just referring only to show that those sections.
Or I can go through it also.
My lord,
quickly.
I'll just refer it to page number 38. Basically, I'm challenging that order, my lord.
38.
38.
Yeah, Chief CJM Bomdila.
That is the order of framing of charge, my lord. The relevant part, if my lord may kindly have the next page, 39. If I may read from the beginning, my lord. 39. Learned additional PP submitted that in absence of CFSL report and seized truck radiator, there is no prima facie material against the accused under section 25 and 27 of the Arms Act. However, there is prima facie material against the accused under section 341, 336, 427 of the IPC. During the consideration of charges, learned PDC have submitted that since there is no CFSL report and the seized truck radiator available with the court, and in the case record, no cases made out against under section 341, 336, 427 IPC, read with section 25 and 27 of the Arms Act. Further submitted that concerned IO has filed charge sheet against the accused only on suspicion. Now, my lord, observation of the Honorable Court. I have considered the submission of both the learned counsel and have also perused the charge sheet along with the entire case report. On perusal of the case report, it appears that the concerned IO has not forwarded the seized truck radiator along with the CFSL report. Hence, it cannot be ascertained that the bullet was fired and the truck was damaged. This is vital, my lord. The bullet was fired and the truck was damaged. Further, it cannot also be ascertained that the accused has acted rashly or negligently. This is the foundation basing on which the whole case was built. There was allegation is there that there was a use of firearm with because of that bullet, it has damaged the truck, and because of that, there was a wrongful restraint. In that way, the whole case was structured. Now, the observation is that bullet was fired and truck was damaged cannot be ascertained. Further, it cannot also be ascertained that the accused has acted negligently or rashly. Now, the next paragraph. However, based on the statement of the witnesses, seizure of the vehicle of the accused, seizure of his revolver, and his presence in the district on the date of the incident. How that can be possible, my lord? In case if a FIR is filed for wrongful restraint in Naharlagun, for a simple reason that I'm in Naharlagun today, I can be booked under 341, my lord. This is how the reason has been given in this.
What did he say? Based on the statements, the witnesses,
Seizure of the vehicle of the accused, seizure of his revolver, and his presence in the district on the date of incident. The foundation is that there was a use of fire.
Who's present? The accused.
Accused present. That is the reason, my lord, all the sections were dropped except section 341. And as of today, my lord, since last 3 years, the prosecution
charge was framed only under 341.
341.
Summons tribal, magistrate tribal, summons case.
Yes, ma'am.
Magistrate tribal.
And since last 3 years, my lord, none of the prosecution witnesses has appeared before the learned trial court below. If my lord may kindly have.
Is it?
Page number 48, my lord. Down below, my lord. Today is fixed for evidence. Someone prosecution witnesses are absent. There are 2 prosecution witnesses only. No report is received regarding someone issued to absentee PW. Hence, issue fresh summon to the absentee PW along with WT to PWB Pusam. Now, my lord, may kindly have the next page. Second paragraph, my lord. Today is fixed for evidence. PW Shri Govind Chetri is absent. And down below, my lord, issue fresh summon to prosecution witness Shri Govind Chetri. Now, the third, page number 50, my lord. Last paragraph, my lord. No report is received regarding someone issued to prosecution witness Govind Chetri. Hence, issue fresh summon to him. Also issue summon to PW Shri Suraj Chetri. My lord, may kindly have page number 51. Down below, my lord, prosecution witness, namely Govind Chetri and Shri Suraj Chetri are absent. Issue fresh summon to PW, name so and so. My lord, may kindly have page number 52 again. Serial number 5, my lord. PWs, namely Shri Govind Chetri and Suraj Chetri, are absent. A late report is received from the OCPS Tezpur stating that the accused person, namely Shri Govind Chetri and Suraj Chetri, are not available in the given address and their whereabouts are not known to any. During inquiry, it was learned that no person by that name are available in given address. Various. Madam, may kindly have page number 53, 54, madam. Serial number 5. PWs, namely Shri Govind Chetri and Suraj Chetri, are absent. Serial number 7. Hence issue bailable warrant of arrest of rupees 500 against prosecution witness, namely Shri so and so through OCPS Tezpur. My lord, may kindly have page number 55. On that day, my lord, the PO was on leave. My lord, may kindly have page number 57, my lord. Thank you. Serial number 5, page number 57. PW, namely Shri Govind Chetri and Suraj Chetri, are absent. Serial number 7, my lord. Service report of summon of PW Shri Suraj Chetri returned with a report. The summon is not known or not found in the given address. My lord, may kindly have page number 59, my lord. Serial number 5. Prosecution witness, namely Govind Chetri and Suraj Chetri, are absent. Serial number 7. Serial service report of summon of PW Suraj Chetri returned informing that summon is not found in the given address, and upon inquiry it is revealed that no one in locality knows the whereabouts of the summon. Considering the service report, no further summon shall be issued to prosecution witness Govind Chetri and Suraj Chetri. They are the informant, man. They are only two.
And what happened to the warrant? Warrant also did not.
Not executed, man. Could not execute. And this matter is pending since last 11 years.
Yes.
So therefore, at this stage, my lord, I won't be praying for disposal, only for the staying of the proceeding, my lord.
Yes, it is since evidence, though trial has started, but only IO, right? Evidence is practically not started. No, isn't it?
Yes,
Practically not started. So at the stage of this final disposal, we look at the charge sheet, whether there was any justification to charge sheet you or frame charges against him, and if not, then it goes.
Yeah.
Yes. But for them, yes.
Here, arms act also involved.
Yeah, no, charge was not framed on the arms.
Arms act was dropped.
341. Prosecution is not challenged the framing of charge under only under 341.
Yes, examination of prosecution witness is required to examine to come into the conclusion that whether there was.
No, I'm not. It can not disposing. It's not. Orders come for. He's not seeking also. Yeah, Mr. Shariki.
Yes, yes.
I go first. Last order, first paragraph. Still. First and second paragraph would be same. The scanned TCR has been received in the meantime. We'll stop. Drawing attention to the FIR dated 26/2/2024. 2014, sorry, 2014. The Nagaland Council submits that none were named in the FIR, though it was alleged that while the informant and another person were coming in their truck AS12C 5833 from Tawang towards Tezpur on near one place, Dumdum Nala, in the afternoon. One vehicle, being a Scorpio with number ARK11, overtook them, and by blocking the way, the driver took out one pistol and fired 3 rounds without any provocation, and thereafter left the spot. It is submitted by the petitioner counsel that though the investigation resulted in a charge sheet, but by the order dated 14/7/2023, charge was framed only under against 341 IPC, and contends that the same is also not justified. The petitioner counsel has taken the court through the copies of the orders annexed with the petition to contend that so far the informant and his companion in the vehicle have not been examined as they failed to appear, and the court eventually directed that no further summons shall be issued. Only the IO was examined and his cross-examination dispensed with. Full stop. So we release the matter for hearing. Finally, you can state, no problem, state. There's no IA, no?
No, I-
There's no IA. The learned counsel praised that as the case arose out of an FIR of 2014 itself, he's being prejudiced. As there are no materials against him and trial is also not proceeding, and seeks a stay in this criminal petition. I've given my consideration to the FED. It is directed that further proceedings of GR number, have we mentioned the GR number?
04 of 2014.
04 of 2014, within bracket arising out of West Kameng 6 of 2000, the West Kameng PS case number.
Rupa Police, sorry.
Rupa PS case number 6 of 2014 shall remain stayed till the next date of listing for the moment. And what else remains to be done for hearing, for final hearing?
Yes, panel.
Should we list it for hearing or at the admission stage only we should?
Admission stage, we can dispose it offline. For admission on.
It has been admitted already. Let us see. If it is admitted, then we cannot keep it at the stage of admission. It has not been admitted. So list the matter
After 3 weeks.
after
3 weeks,
after 3 weeks in the admission column.
admission call.
Okay.
They get to be fixed by the registry.
Here also I'm seeing there's a problem. Hearings are not reaching much. So we need a different model. We need a different model, I think. So that it reaches 20.
Grateful.
Item number 25.
50 minutes left. That is the thing, na? Hearing comes up at the fag end actually. Though it should be, one should take up hearing when one is most fresh, you know, all of us. So maybe we need some adjustment. Then it will be, both new matters also have to go on, admission order matters and hearing also need. Let me just see it.
So order 43, rule 1, application 1.
Injunction?
Injunction was really granted by the subsequently it was vacated.
Vacated.
Therefore, it is then appeal. Well, what happened, my lord, I am the plaintiff has filed a suit for right title, interest and recovery of possession along with the application under order 39 rule 3, 1 and 2, my lord.
Just a minute. Wait. I'm just seeing. Where is the cost title? Cost title.
FA of 5.
I think it starts from here. Sorry, one. We don't have much time actually, but anyway. I'm just checking this. 2 respondents, 1 pro forma respondent. What about service? Is it complete? You are appearing?
My lord, I am appearing for the respondent number 1 and 2, not for the pro forma.
You are appearing for respondent number 1 and
2, my lord. My lord, this matter will require some detailed hearing.
Yeah, it may. At least sometime it will need. Anyway, I'm just, seeing, pro forma respondent
They
required
have
to be,
appeared, my lord. They
they-
have earlier appeared.
they've also appeared.
Service has completed, my
So
lord.
no
They have
issues.
no request.
So matter, so, record has come.
My lord, no record is required, my lord, although we have annexed all entire documents, my lord, with the appeal.
No record is required. The injunction matter, no record is required.
Otherwise, records are there.
It's there.
Yes, yeah.
It's okay. If the materials are there and it's not disputed by the other side, it
Yeah.
can be, you know. But can we take up only 10 minutes?
But it will
Not
take some
possible.
time, my lord, not
No.
possible. Not
Take time.
It'll take time.
Then he has to make argument, then I have to.
Yes, yes. No. It's not possible.
Not
It's possible. Anyway, because I'll be going this week, so I keep it part hard. It will be stuck. Anyway, Srila Vitta Learned Council appears for the appellant. Learned Council appears for the respond number 1 and 2. The Learned Council, the Learned Appellant Council submits that the respond number 3/pro forma respondent has also entered appearance earlier.
Yeah.
The hearing could not be taken up today due to paucity of time. This is the matter. You take a date. You've come from Guwahati, no?
Yes.
You can take a date as per your mutual convenience. You can take a date.
Can be possible next week because there is some urgency in my side.
I can give it next week. You can next week.
Then on 20.
20.
Yes,
Can we make it 21?
okay, fine.
21. On 21.
Can we top up? This is the matter on top of 2111 as prayed for by both the learned councils.
Be on the top of the list, my lord, because otherwise, my lord,
So, well, actually, top of the hearing list. So,
Your lordship, this is the 5th time that
no, this is a problem. It's a problem. But I said, no, we need to, we have to, we have to think of another model. It's not reaching. There it's more, but here also I've seen. Here I was expecting that it will reach, but here also it is similar thing. Actually, Arunachal, it has, Itanagar has matters, you know, it has matters. It has matters. So in Kohima and all that, maybe it's not reaching. So top of the list, actually, you know, unless it is, would you mind if I fix it top of the hearing list? It may reach also. This is the matter on the matter may be listed at the top of the hearing list. See, we can, you know, we have to think of some innovative models.
Yes.
Like something like this, that we start in the 10:30. We start with hearing, suppose, but we don't do, so it's not be like that, that we do the hearings. If we do the motion admission orders, then the hearings get left over. And if we start with the hearings, the whole day is consumed by hearing and we cannot start motion. So we can split it up. That, you know, that we 2 hours we take hearing and then a break. Then we start taking motion orders. Then both things will reach.
Yes.
And you can even keep a separate slot for orders because sometimes orders don't reach, but sometimes important things have to be, you know, done in the order stage also. So that kind of thing we can think of. These kind of models have to be thought of. Then we can go parallelly, you know, like, you know, every day we are taking hearing, but we are segregating slots, right? And if keep it flexible, suppose you finish it early, then you can, with the consent of the councils, you can bring in another matter from another category. Otherwise, we'll keep facing this problem. Hearing at the end of the day is actually not scientific. Not scientific. Your mind has to be the matters which require more, you know, time, more attention. They have to be taken, but everyone is more fresh. Like our studying, you know, something, you know, we don't think difficult. We study when we are fresh. Anyway, so this is done. Another hearing is there. So we have fixed it on 21st. 2111. At the top of the hearing list. If it still does not reach, then maybe we can.
I was ready to accommodate.
No, very fair of you. That should be the spirit, actually. Very nice. Council here.
Item number 26.
Let me just see what is the matter. RCP.
This is civil revision, my lord. Against Kava Parwana. my lord.
Kabang.
Yes, my lord. Kava Parwana dated, my lord, 5/6/2024. My lord, complaint was lodged, my lord, against petitioner on the before Gaubra, my lord, village authority, my lord, on the ground that petitioner had taken bride price of respondent number one's daughter.
Bribe.
Bride price,
Oh, bride price.
yes.
Yes.
But my lord, which is, my lord, not true, my lord. My lord, no bride price was paid, my lord. And
But sir, I think there'll be no time today.
yes,
We
my
have to fix another date, right?
lord.
Learned Counsel, good name, please.
LNOC, my lord.
LNOC, Learned Counsel. Appears for the petitioner. And how many respondents are there?
My lord.
Two, my lord.
Two, my lord.
Two. You are appearing for both?
For both, my lord.
Learned Counsel. So appears for both represents both the respondents. Hearing could not be taken up today due to paucity of time. Work out a date. Is the matter
After 3 weeks, my lord.
after 3 weeks.
Yes,
At least after 3 weeks. Should I fix a date?
Registry may be.
Yes. If it does not reach, you make a mention.
But my lord, can it be on top of the hearing list, my lord?
Top of the hearings.
Otherwise, my lord, since last.
Top of the hearing.
three,
No,
four
no, as I
occasions,
said,
we are, trying
we
to-
have to work on this. We have to work. So much technology involved, available today. I'm sure we can solve this problem.
Weekly.
Always.
Top of the hearing list.